your case, but there's a lot of cases. When your name's called for review, come up to the table to the right. I'm going to review your file with you. If you don't get called, think you should have, go check in with the clerk.
Darius Aldridge, William Cottle, Darren Horn, Ronnie Gillespie, Lisa Hodge, Destiny Gerald, Stephen McGinnis.
Darius Aldridge.
Good morning, Your Honor.
2512 is here today. You just have to finish your community service. You have done some since
Yes,
the last
sir.
hearing. Okay, I'm going to set it for November 24th will be your next hearing. If you get it finished by then, you don't have to come back.
Yes, sir, thank you. I should have this, I've got a boot on right now, it's last week, and after I get this off.
Okay.
Thank you, sir.
November 24th, 9 o'clock.
24th?
William
Yes,
Cottle.
sir. Yes, Your Honor, right here.
251812,
That's my community
25448.
service. I've got some community service right there.
Your Honor, he has turned in 12 hours of community service. It will be accepted.
Okay.
I've been having problems where I'm in JFT. I can't come up here. They won't let me out of group to do your all's community service. So I've been having to
Where's
do.
that located? Just today?
It's in Ironton.
Okay. Well, I'll let you do community service at Ironton Municipal.
He's doing it at the animal shelter, Your Honor.
Yeah,
Okay, that's fine too.
yeah.
Okay, can you pay anything on your fines?
Yeah, I got 120 today. I was going to pay.
All right, see the clerk to make that payment.
I got a quick question here too, Your Honor. I got this in the mail at my parents' house from West Virginia DMV. Here it says, what does it say here? Your driving privileges are revoked till November the 18th, 2025, because you convicted a motor vehicle on July 21st. Does that, my driving privileges, does that cover me, like West Virginia?
Yeah, West Virginia, all states have a license issuing agency, and that's what it is in West Virginia. So they're suspending you because of this conviction.
Okay, but the driving privileges you've given me, like, because I go to the VA hospital and, all that, so I was just making.
Well, I'll say this. We've never had a problem with West Virginia. Kentucky, we have had a problem.
Yeah, I heard.
A few times where people have a permit and they don't accept it, so.
Okay.
What I would say, the best thing to do is,
Stay out of Kentucky.
what I was going to say is, it's not that hard to avoid getting pulled over.
Yeah.
Don't speed, use your turn signal, stop at stop signs. Okay?
Okay, when's my next court date, Your Honor?
Okay, hold it down, folks. In other words, no talking in the courtroom. November 24th will be your next hearing, 9 o'clock. Darren Korn. Darren Korn is 2496 and 23761.
Thank you.
You're welcome. He's not appeared and he still has lots left to do. So there'll be a warrant issue for failure to appear. Ronnie Gillespie, 24601. Is that Orange County Recovery? That's a good report. Okay, very good. You just need to work or pay off your fines, so you pay anything today?
Can I work them off? I
Yes, sir.
finished my outpatient, so it gives me a little bit more time to where I could work it off.
Yes, you can.
Okay,
So just get out here any day this Sunday at 7:30,
all right.
and that'll go towards your fine. November 24th,
Okay.
that's your next hearing, 9 o'clock.
Your Honor, do you have the total of this fine owed?
$325.
Thank you.
Lisa Hodge, 15,611.
Thank you very much, sir.
You're welcome. Lisa Hodge still has fine to pay, has not appeared, so there'll be a warrant issued. Destin Gerald is here, 23,595.
Your Honor, if I may, she's turned in 3 hours of community service this morning.
I went to come Thursday and I was a little late because I had to drop my son off to the bus, so I just had to hurry up and do some through the food pantry because I couldn't make
Okay,
it.
well, we're getting there. Let's try to get it finished.
Okay, how many hours is left?
Well, that would make 11. You got 11 hours left. So I'll set it in December the 8th. Get it finished before then, you don't have to come back.
Okay. Thank you.
You're welcome. Stephen McGinnis.
He's on Zoom.
All right, Stephen McGinnis.
Yes, sir.
We got Shawnee. And now you're working at Shawnee. Okay, very good.
Yes, sir.
Okay, you got community service and still have fine to pay.
Yes, sir. I paid $100 this morning on my funds,
Okay?
and I'm going to go over to the community services on Saturday. We only have one driver on Saturday, so I'm looking forward to getting my license back right now. I was looking at your report on the 11th to come back. I paid all my stuff in Kentucky for my reinstatement fees and fines. So I'll let you know, I paid my reinstatement fees over here, and I'll be able to get my license back. I'm in the process of working on that right now.
Your Honor, if I may, on
So
September,
I'll do that. That's community service.
Mr. McGinnis was ordered to do some community service before his next hearing, and he has not.
Okay. This case is getting a little long in the tooth and you haven't done any community service, so we gotta get it done.
Okay, yes, sir.
Otherwise, it's jail. Community service is in place of going to jail, so it's
Yes,
much
sir.
better to do the community service than go to jail. So no excuses. Let's get it. If you gotta hitchhike, whatever you gotta do, man, get it done. Don't make any more excuses. I don't even want to hear them next
Yes,
time.
sir.
I want to see that you get some hours done.
Okay.
November 24th, 9 o'clock.
Thank you.
You're welcome.
Thank you, Your Honor.
Michael Merswinski, Reuben Mitchell, Otis Sexton, Misty Shaver, William Turner, David Vance, Mark Wells.
Michael Merswinski is 24,176. He's been called. He's done a lot, but he hasn't finished. He's not here, so there'll be a warrant for failure. Reuben Mitchell, 133933. He's not here. He has a lot left to do. There'll be a warrant for failure to appear. Otis Sexton, 24,539, 24,770. It's not completed. There'll be a warrant for failure to appear today. Misty Shaver, 17,3465. Should we have a report?
Your Honor, she turned some community service in this morning. I do not remember how many hours.
16.
It was. How many?
16.
16, that sounds correct.
Okay. And you got a report from UFR. There was a little small hiccup, but it looks like everything's good now, and
Yeah,
Otherwise, it's a good report.
I was sick and I fell asleep and I missed my test by 2 minutes.
Okay.
But, yeah, it was still my responsibility.
Can you pay anything on your fines?
No, right now I'm here waiting to hear back from Thoroughbred, and I just put an application at BW
Good
here in
job.
Buffalo Wild Wings, yes, sir.
Okay.
I've got a little bit of a savings that I'm trying to get, because it was in mine and my husband's name, so as soon as that's available, I'm gonna pay that, I'll probably be able to pay my fines off. But as soon as I get an employment, my first paycheck, I'll pay all my fines.
Okay, I'll set your next hearing for November 21st. That's it. That is Friday.
All right,
9 o'clock, November 21st.
thank you, Your Honor.
You're welcome. William Turner, 24,653. Right, you're Mr. Turner. You just have to pay off your balance. Do you have a payment today?
It's done. It's paid for.
You paid it today?
Paid it last night.
Okay. Well, those don't, so you paid it online. Well, it'll probably hit later today. So what I'm gonna do, I'll give you a date. If it is paid off, you don't have to come back.
I got a receipt.
I'm giving you a date. If it's paid off, you don't have to come back. November 21st at 9 o'clock. David Vance. '24, 1921, 2550. David Vance. Is not finished and is not here, so he gets more. Mark Wells is here. Case numbers are 17-1273 and 20-2014-2753. All you have left is fines to pay. You did your community service, so you have a payment today, Mr. Wells.
Yes, 10.
All right, see the clerk. I'll set you for November 21st. 9 o'clock, so next meeting.
All right, thank you.
Go see the clerk. Okay, that finishes reviews. Anybody that's got new cases, come in the courtroom now, or an old case where you've got a warrant and want to recall. I'm going to explain the rights that defendants have to all of you, but I'll go over with the individuals as your case comes up if you have questions or you didn't understand something. The rights that you have as defendants were set forth in a case called Arizona versus Miranda. You have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have an attorney appointed if you can't afford one. You have a right to bail. Make sure they will either prove the charge beyond a reasonable doubt. If you decide to enter guilty or no contest plea, you're waiving your rights. You should not waive your rights. If you want a trial, if you want to talk to a lawyer, if you don't know what to do, if you're confused, you don't understand what's happening, not guilty is the plea you should enter. You can always change it later to guilty. Call the first case.
State of Ohio versus Shania Westmoreland, case number TRD 18228.
And you're Shania Westmoreland?
Yes, sir.
All right, ma'am, it's alleged that you had failed to appear for a review hearing back in 2018, September 14, 2018. It was on a conviction for driving without a license. Do you admit or deny you missed your hearing back in 2018?
I admit it.
Do you have an explanation?
Back then I was into a bunch of bad stuff. I just got out of prison in June 26, 2025.
and I paroled to Ohio, so I'm now currently a resident of Ohio, and I'm just trying to get everything resolved.
Okay, where do you live now?
101 Brubaker Drive, apartment B6, South Point, Ohio.
Okay, I withdraw the warrants that you came in on your own, you didn't get arrested. And just like the people that were just here on reviews, I'll set review hearings. So as long as you're making progress, come to do reviews, I'll keep working with you until you get it done. I'm showing you 5 days of community service and $185 in fines and costs. So we've got a community service program here at the court. You can get here any day other than a holiday or Sunday at 7:30 and do community service. And if you can't pay your fines, you can do extra community service to work off your fines.
Yeah, I currently have a job.
Okay.
I just started, so.
What's your work schedule?
Monday through Friday and Sundays.
Okay, well, that'll work out good, because Saturdays is a day you can do community service.
Yes, sir.
So let's give you a date in December.
Okay.
It's gonna have to be a Monday or a Friday, does it matter which day?
No, I work evening shifts, so it's okay.
Okay, so morning's okay. Let's do the 1st, December 1st, that's
Okay.
at 9 a.m. on December 1st will be your next hearing. Just come to these until you get everything finished. Complete your case.
Thank you so much.
You're welcome.
State of Ohio versus Raymond Wall, case number TRD 23530, A, B, and C. Raymond Wall.
And sir, are you Raymond Wall?
Yes, sir.
Mr. Wall, it's alleged you missed a hearing on Friday, I guess it was. Yeah, the
Yes.
17th.
Yes, sir.
And it was said as a sentencing, you were trying to get your license back?
Yeah.
Have you been able to do that?
No, sir, not yet.
And you got a bond up now. What do you need to do to get your license back?
I think just pay my reinstatement.
Okay, well, that shouldn't, how much was that?
I'm not sure.
Well, do you want me to just go ahead and send you, or do you want more time to try to get your license back?
I need more time.
How much time do you think you need?
Trying to find some work right now. Kind of homeless, in between homes.
Okay, I'll reschedule it in a month. So let's make it December the 19th. December the 19th is your next hearing. That's a week before Christmas. There'll be a sentencing here, 10 o'clock.
Thank you, sir.
Well, a week and a day. Christmas is on Thursday this year. Okay.
State of Ohio versus Robert Skaggs, case number TRD 24212.
Okay, this was set for a hearing on the 6th of October, and so why did you miss that hearing?
I've been in the hospital. I had some heart failure, blood clot in the lungs, and wasn't doing very well. They put me on this defibrillator. I have paperwork for that if you need to see it.
Okay, yeah. Mr. Cooper, can you give he has his documents? You paid most of your fine.
Is this his to keep or do you get it back?
That's the only copy I have, but, I mean, if you... About 11 different medications and all that crap.
So you went to SOMC.
Yeah. I gotta go see, I guess a specialist. They said it was like 35% of my heart was working, so.
Okay, I'll accept your excuse. I'll reschedule you for a hearing on November 21st for sentencing at 10 o'clock. I'll cancel the warrant. November 21. 10 o'clock is your next hearing.
All the agreements we have for right now, I'll get that pre-trial.
Okay.
Thanks, sir. Have a good day.
You too. We need the lawyers in the courtroom, please. We got Mr. Ashworth, the special prosecutor, and he's appearing by teleconference. He's got 2 cases, we're going to go ahead and call his.
State of Ohio versus Stephen Davis, case number CRB 25-599.
That's Morford's case.
I don't think.
Is Mr. Morford here?
I don't believe he is, Your Honor.
Okay, Mr. Davis, you'll have to have a seat. Your lawyer's not here yet. We'll call you when he gets here.
Here?
Back behind the bar. Okay.
State of Ohio versus Raymond Meredith, case number CRB 25-167, CRB 2038.
And this is Mr. Stratton's case. Mr. Ashworth is special prosecutor.
Your Honor, I have spoken with Mr. Meredith this morning. He is supposedly in a hospital this morning. He's supposed to give me some paperwork that I have not received yet. We talked about the offer from the state. The state has offered a disorderly. Mr. Meredith has indicated that he will not accept that. So we could just set it for trial, but he has been in communication with me today.
Your Honor, I just learned recently that the victim, in this case, her mother was assaulted last night by Mr. Meredith, and she is actually in hospital with a broken hand, and they are filing a domestic violence charge. I would like to set this for trial, sir, and no more offers of it. All offers of trial.
All right. I'm going to go ahead and issue a warrant for Mr. Meredith since he hasn't appeared today.
Yes, Your Honor.
Your Honor, if I may, I had a note that Mr. Meredith was ordered on 9/6 to put his beer for some community service for the next hearing. He is not in.
All right, thank you. Because he has an old case where he had community service to do. So there'll be a warrant on it also. And I expect then there's going to be new charges filed. I don't have those yet.
I don't get it, Your Honor. I think they're in process. I'm not sure if they will come to me because the mother is the victim. I'm not exactly certain of that will generate conflict with prosecutors also not. If it would, it might make more sense to try those, but at the same time, nevertheless, I probably just go ahead and ask for a trial date today if you get one.
Well,
I'm just going to issue a warrant for him since he didn't appear today. So once we get him back before the court, then I'll set it. When and if we get him back, then I'll set a trial date then.
yes, Your Honor. I'll tell him to come in as soon as he gets out of the hospital.
Thank you.
State of Ohio versus Justin K. Thomas, case number TRC 25-1274, B.
Ms. Harvin sent you a number, Mr. Stratton, to call for that other case.
Do what?
Ms. Harvin texted you a number for that other case.
Oh, I spoke to her.
Okay.
I've got an update when we call next call.
Good, thank you. All right, this is Mr. McCown's case, Justin Thomas. It's set for a pre-trial today.
Good morning, Your Honor. Your Honor, we spoke about this previously today, and I know the court has asked us to brief this matter. What I'd like to do, if it's okay with the court, I think there's some clear case law on it. Just I need to verify it, but if we could do this, I'm sure Mr. Hill will want to obviously research it as well. But if we could set this maybe for a pre-trial in 3 weeks upon the brief of the issue that we discussed, and what I'd ask, Judge, if we have a dispositive motion, if the court agrees with us, if the defendant wouldn't need to be present for that. I mean, it'll either be disposed of or the court's going to set it out for a further full suppression motion, I would presume.
That's fine, and I will respond to Mr. McCown's. You're going to file a written motion?
I'll send you mine, sure.
So, when do we file your motion and brief?
Your Honor, I should have it done within 10 days. So if we could do, say, November 10th, that's, I think, 3 weeks out.
Well, I want to give the state time to respond.
Is that enough time, Phil?
Should be.
So you're going to file by October 30th. And set up for pretrial, you said November 10th?
Yes, Your Honor.
November 10th will be pretrial and motion.
And does Mr. Thomas, is it okay?
He does
if-
not have to be present.
Thank you, Your Honor.
November 10th, 10 o'clock, so next day.
Thanks, sir.
State of Ohio versus Timothy R. White, case number CRB 25-530, A, B, and C.
All right, this is Mr. McCown's case set for pretrial.
Thank you, Your Honor. Your Honor, I've spoken with Mr. Hill about this case. It's my understanding, I think we're going to ask for a 60-day continuance. He's talked about the defendant seeking an AOD assessment and anger management counseling, and has indicated that completion of those would greatly affect how we proceed in this matter. So we had asked for a 60-day continuance for him to be able to complete such a program, and we'd wait time for that.
Mr. Hill.
And Your Honor, there's two separate cases here. One of them involves a menacing charge with the victim, alleged victim being Aaron Atkins. So that's a separate matter, and we've discussed that fact with Mr. McCown. The domestic violence charge, an M4 domestic violence charge, and then an obstructing charge that happened during the arrest are the subject of this other situation in which we have requested that Mr. White do the anger management and alcohol counseling. And there was also some indication maybe that marriage counseling, I don't know if
They're doing that separately.
and if they are doing that, then we would be encouraging that as well.
So was there already an agreement on the other case for your counseling? Is that?
There is not a full agreement on the menacing case, Your Honor. We would ask for a continuance on that. I think his...
I don't have that file in front of me, so was it set for today? Is that on a different file?
We thought it was for today, and that is
You have a case number on it?
25 CRB. Oh, it's in the same time frame.
I think
530C, it's a C.
It's a C case, yes.
It's a part of this thing.
So it is, Your Honor.
Yeah, there is menacing on the same day. Okay, so I'm a little unclear as to what the agreement is. The defense asking for a 60-day continuance, and is there agreement that he's going to get an assessment and counseling?
Yes, that is correct, Your Honor. It's my understanding that it would resolve the domestic, the obstruction. There's still no real agreement on the menacing, but I believe the state has indicated that it may impact how they view that case.
Okay. And state's agreeable with that, what's being represented?
Yes, and the only reason, the 60 days, I think, is just we're agreeable with that, but only to make sure that Mr. White gets involved in the counseling. And when he comes back, we want to have a report that shows that he's actually doing that.
Has this started yet, or is anything?
Not yet, Your Honor. This is the first pretrial that I've attended.
Does he have a relationship, or do you have an agency that he wants to go to?
Not,
I don't, I'm sorry.
it's okay. No particular one yet, Your Honor. He does have insurance through his employer.
Okay.
So,
Well, unfortunately, that probably makes it harder.
yes, I understand that.
So, he can go, is he a Ohio resident or West Virginia resident?
Ohio.
Ohio. OVP will take medical insurance. The more medically based agencies in Huntington, like Valley Health, Proact, those are some of the ones where he may be able to use his insurance, health insurance. So what I want to see happen, I don't want to put this off for 2 months, and then, because I've had this happen, put it off for 2 months, come back and say, well, I just went and got my assessment yesterday. Well, we wasted 2 months.
Yeah, that's not the expectation, Your Honor.
So he needs to start on this immediately. December the 19th, will be for pretrial at defendant's request.
State of Ohio versus Dylan Adair, case number CRB 25609.
Maybe approach, John.
Yes, Mr. Stratton is representing Mr. Adair.
Larry McNamara. Because I don't think anything about that's how serious it is to say about pursuing it, or just one of those where you just want to get treatment. I know she was working on finding another placement for it after the year passed. Okay, this case is going to be continued to Friday. We should know more about Mr. Adair's situation then. So, 24th, 10 o'clock for pretrial.
State of Ohio versus Jaden Nybert, case number CRB 25465.
Your Honor, this is an assault case. Come to find out that there's a video of the incident, which might present a defense for my client. The state is not in possession of that. We will get a copy of that and get it to the state, and hopefully that'll resolve this case at some point in the future.
So you're the one that has access to the video?
I believe he does, or knows how to get access to it.
The defense has
Yes.
access to it. When can you obtain this?
I could send it to him today.
Okay, you have it in your possession.
I'm not yet, but
He does.
He does, yes.
All right, so we just need to set another pretrial.
Yes. Yes, send it to my number.
Anytime in November except the 7th.
Anytime except the 3rd, 10th, and 24th. Those are our trial dates, Your Honor.
Okay, how about the 14th?
Yep, that'll work.
November 14 will be the next pretrial,
So send that to
10
me right now.
o'clock.
Okay, thank you.
Defense is going to provide video to the state as soon as possible.
All right, thank you.
State of Ohio versus Stephen Davis, case number CRB 25-599.
Morphy's case and Mr. Ashworth.
He may have hopped off, Judge. When you sent me a text, I called him.
Okay.
He said he's gonna hop off, and I just texted him again what the case was about. I believe it's our first pretrial.
Is there any agreement or?
No, we didn't discuss that, Judge. I wasn't aware that Mr. Ashworth was on the case until you texted me.
Okay.
So he said call him and he'd hop right back on.
All right, do that. We'll go ahead and we do some other cases. We'll call it back up.
Okay, thank you, Judge.
State of Ohio versus Amanda White, case number CRB 25-552.
So what's his
Mr. Stratton's case, that's a pretrial.
He said today too, right?
Yes.
Okay. There's a cross-filing on this also, Your Honor. What was the name again? I'm sorry, Jeremy Northridge, right?
North Edge.
Northridge.
It's not a crossfire.
They have it typed wrong.
Okay, they have a typo. Okay, all right. It's not a cross-filing, but I think it's, we need to call that case along with this one, because
Who's
whatever.
the attorney on that?
Mr. Morford.
Okay.
It's from Northridge.
That's North Edge.
Yeah, okay. Because what he does with that one depends on what we're doing with our case.
State of Ohio versus Jeremy Northridge, case number CRB 25-550.
Mr. Morford's case.
Thank you. Your Honor, as far as our case is concerned, I don't know if he's going to plea or he's going to set his for trial, but we're definitely going to set ours for trial. But I'll let Mr. Morford.
We're going to have a change of plea, Your Honor.
Okay, so that's on Jeremy Northridge, this 25-550, there's going to be a change.
Plead guilty.
Is that correct, Mr. Moore?
Yes, sir.
It's North Edge, right? Not,
North Edge. Yes, sir.
no R, no second R in there.
Yes, just like the north edge of town.
Okay. And this is on a Walmart theft offense.
Yes, sir.
Okay, so what I'm going to do is my typical procedure on these is where you do a urine screen. Go do a urine screen. After I get the results, I'll send you when I see those.
As for our case, Your Honor, Mr. North Edge was the one responsible for this. My client was merely present. This whole situation was unknown to her, so the state doesn't we want to dismiss this case, we just need to set it for trial.
Okay, what's the state's position?
Well, we're willing to look at the evidence. Actually, I haven't even seen the video of this yet, so I'd be willing to look at it. And I mean, this happens occasionally. One person doesn't know the other person's going to be doing something like that. But so if we wanted to have another pretrial, have you asked for
That's fine.
discovery in this?
I believe I have, but anyway, we'll set it for another pretrial, Your Honor.
For that 14th day?
Yes, that'll work.
November 14 will be the next pretrial for Ms. White, 10 o'clock.
I'm sorry.
All right, good to go.
State of Ohio versus Wesley Wright. Case number TRC 25-380, decision. CRB 25-461.
Yeah. That was a mistake. It's not actually. Is there another case? This is Mr. Stratton's case, Wesley Wright.
Yes, I have not heard from Mr. Wright, Your Honor, so if we can, 7 days before warrants issued on this, or 7 days to get him in here.
Yes, he has OR bonds out, so the warrant issued in 7 days if he hasn't appeared.
Thank you, Your Honor. Are the prisoners here yet?
Your shot.
State of Ohio versus Stephen Davis. Case number CRB 25-599.
This is not Mr. Ashworth's case, this is prosecutor, regular prosecutor's case, and it's Mr. Morford on the defense.
Pretty good. How are you? I'm good. And you? What? Have we been any problems? No. Late.
Okay. Should we? Let's bring a subpoena victim.
What can we do on this case today? It's the first pretrial.
Your Honor, when the case first came before the court, we did hear from her, right? Immediately after, or not?
Yes, I talked to her and she wanted protection order agreement and I couldn't get hold of her.
Okay. Since the case first started and the alleged victim requested the protection order, we've lost contact with her. So we have what we believe is a good address. We'll try to subpoena her to that address.
And how much time do you need to get that done?
I would say about 3 weeks.
November 10th, are you available, Mr. Morford?
Yes, Your Honor.
Okay. Next hearing will be 11/10, 10 o'clock.
See you later. I'll be here to talk to you before come up with this appointment. Okay. Cool. Thank you, Judge.
You're welcome.
State of Ohio versus Jaden Moore, case number CRB 25591, CRB 25570.
You're good.
This is Mr. Morford's case, and I believe Mr. Moore is on teleconference. Yes.
Judge, I believe is at Bellefonte.
Yes.
Receiving treatment there. How you doing, Jason?
I've been doing pretty good now. I was diagnosed with a bunch of different conditions and given a bunch of medications and stuff, antidepressants and antipsychotics and stuff. And now I'm in treatment at a rehab place, so and things have been going good. So.
He's actually, I remember, he's at White Light now. He's not at Bellefonte anymore. Is there a number there where your lawyer can call and talk to you?
I don't remember, Your Honor.
Okay. Have they told you how long you're going to be there? Any prognosis on dates, how long you'll be there?
Well, this particular, what I'm in is PhD, that lasts a month, but then you move to IOP, which can last up to a year, I believe, Your Honor.
Okay. Would you like to talk to your lawyer then about things off the record? We're on the record now, you're appearing in the courtroom on teleconference, so you could have a more private conversation with him off the record.
Would you like for me to call you, Jaden?
I suppose I would like to keep my counsel a little bit.
Okay. I don't have a phone number. I do have an email from White Light that may have some contact information. I'll send that to you, Mr. Morford.
Do you know where they're located, Judge?
Columbus.
Columbus? I'll Google them.
All right, so what I'm going to do, I'm glad you're doing well there, and I'm just going to periodically check in with you in the form of a hearing to make sure you're still continuing to do well. So we'll set another hearing date out in the future, and you can appear by teleconference just like you are today. How about the 31st? I like to keep a pretty close handle on this one.
I'm here, Judge.
Okay, I'm going to set your next hearing for October 31st. And you can appear by teleconference, and Mr. Morford is going to call and talk to you as soon as possible to make connection. And if you have questions about the procedures and so forth, you can ask him off the record. Anything else you want to ask me?
No, Your Honor.
All right, good luck. Hope you do well there. Continue to do well.
State of Ohio versus Larry McNamara, case number CRA 25647.
I do, Mr. Morford, on White Light, I do have a contact person that I've got an email from. I'll forward that to you.
Thank you.
Okay.
Yeah. Doing great. They're checking me now for a QRT program. I don't know if I'm gonna be eligible for it because of my extensive record. I have quite an extensive record.
Mr. Morford, I've got two addresses for you, Yahoo and lawoffice.gmail. Which one will you, or both? Which one do you want me to send it to?
Morford Law, or Yahoo.
Okay, I sent it.
Thank you, Your Honor.
Okay, looks like we got some work to do and that we started the work, is what I would say.
It's agreed.
State, you want to continue to keep it here in this court?
Yes, Your Honor.
Yeah. Yeah, we do this right.
November 10th?
You know what I mean?
Let's go, Judge.
November 10th will be the next hearing.
State of Ohio recalls Jeremy Northedge, case number CRB 25550.
Thank you, sir.
Yes, sir.
All right, he has an acceptable urine screen, so I'll just go ahead and sentence him. Is there anything you want to tell me, Mr. Northwich,
Yes.
before I sentence?
Yes, Your Honor. This involves partly Amanda White's case. At the time of the incident at Walmart, I was the one that stole the Pokemon cards. I made the choice of my own volition, and she wasn't aware of what I was doing when she was in the bathroom and came back out, and I had already done what I had done. And I didn't want her to end up with a charge for something that she did not do. This is strictly and solely on my behalf that I did this, sir.
All right, thank you for that statement. The charging decisions are not made by me, they're made by the prosecutor. So they can consider, Mr. Hill will consider what you're saying and the other evidence, and he'll make a decision whether he wants to go forward with the case or not. But I'm sure what you have to say will have an impact. Is there anything else you want to tell me, sir?
I'm ready to do whatever to fix what I've done.
I'll impose a $100 fine and court costs, 10 days in jail suspended. We're used to do 5 days of community service, and we have a community service program here. You can work any day but Sunday at 7:30 a.m. and get your community service done that way. 2 years of low and 5 probation. You're ordered to stay out of all Walmarts. And your review hearing will be April 27th, so you got 6 months to get this done.
Yes, sir.
If you do, you don't have to come to the review hearing. If you don't have it done, you gotta show up. If you don't show up, you'll get a warrant. That's the way you can go to jail if you blow it off and don't come to your hearing.
I'll have it done, and I'll be here on the court date, sir.
Okay, if you have it done, you actually don't have to come on the court date. The hearing is to make sure people do what they're supposed to. So if you do what you're supposed to and have it all finished, you don't have to come to the review hearing. If you
Yes,
don't
sir.
have it all done, come, show up, make progress, and then I'll work with you to get it done. 'Cause I
I'll
can
have it
fill out
done.
5 Florence County jails with people. If I held them to a strict standard, you gotta get it done like in 2 weeks.
There's more than enough time here, Your Honor.
Yeah, so you got plenty of time. Get it done and put it behind you.
Absolutely.
Go see the probation officer before you leave, though.
State of Ohio versus William Spalding, case number CRB 25601, ABCD&E, and case number CRB 23512.
William Spalding is set for pretrial today.
Judge, we got a call early this morning at the office that Mr. Spaulding had been admitted to the hospital with a suspected heart attack. I don't have any verification I can provide to you yet.
Well, he has a bond up, so my suggestion would be to ask for continuance because of the bond. Then he doesn't show up to the next hearing.
I would so move.
November the 10th will be the next hearing. 10 o'clock.
Thank you, Judge.
You're welcome.
State of Ohio versus Timothy W. Dow, case number CRB 25589. Mr. Steiner.
Mr. Steyer's case for pre-trial.
Are you treating anything?
Not treating anyone. Minute reads.
Is Ben Reed's here?
They were.
No.
Were the two parties go away?
Yeah.
That you signed papers for them to fax to the judge?
Is Mended Reed's here? Okay, I don't know if they've sent a report.
Don't have anything.
Maybe need to get this recall, and I'll try to contact Mended Reed's and see if we can get a report sent in.
All right, this case will be recalled later in the docket.
All right, have a seat.
State of Ohio versus Joshua Literal, case number TRC 211046.
It's Mr. Steyer's case, pre-trial.
Your Honor, we had asked to have this one added on because of a scheduling issue, you may recall. I've spoken to Mr. Literal about this. This is an OVI with a refusal from several years ago. Mr. Literal is agreeable to entering a guilty plea at this time. The state has offered 3 days in jail. This is a first offense refusal. The state's offered 3 days in jail, or 20 days in jail suspended to 3 days, or the DIP program, a fine at the court's discretion, 6-month license suspension, 30 hours community service. Because this is an older case as an ALS, I think the license suspension is actually already over, because it would have dated back to the date of, it would have automatically attached on the date of the incident.
Does Mr. Literal have an explanation for not appearing for 4 years?
Honestly, Judge, I didn't know that I had a warrant. I went through 3 background checks. I put myself through nursing school, and they never showed up. But whenever I went to get a job at King's Daughters, which I'm supposed to start Monday, it showed up on that, and I came the next week.
Yeah, and he appeared on under his own steam and came in, entered a not guilty plea, and got an attorney appointed at that point. So I'm not sure how he failed to know, how he didn't know he was supposed to be here, but I don't think that, obviously in the 4 years, the warrant never caught up with him. And as he said, he's had some background checks that didn't turn the warrant up, and as soon as he found out about it, he came in.
Well, he was cited to appear on May the 10th of 2021, according to the citation. Did someone steal your identity and you weren't the person served with this, or? I mean, it seems to me that he gets stopped by the state police and cited for driving under the influence, and it says he refused to take tests. That's kind of a memorable thing, I would think.
He was hospitalized as a result of the events as well, so that may have contributed to his confusion.
What it says on the one citation, on a motorcycle on private property, fell over, it slid down the driveway into a ditch. I don't have a crash report. Was there a crash report prepared?
Well, there may have been, but we didn't get one.
You don't have it? Okay.
No. So I don't know if you've got the statement of facts.
I don't have anything but the citation and that was written on the ticket, so.
I can read that into the record.
Yeah, I'd like to hear that.
This is, he was trooper stunt at that point in time in 21. I was dispatched to a physical altercation on private property on State Route 243 near milepost 3. I was advised by the Portsmouth Dispatch Center that I needed to respond to assist the Lawrence County Sheriff's Office. Upon my arrival, I was advised by Deputy Mullins that Mr. Literal wrecked his motorcycle and was highly impaired. Deputy Mullins stated he wanted me to be the primary officer and to handle any charges. Upon speaking with the residents at the home where the altercation occurred, I found that he was attempting to leave on his motorcycle and wrecked at the top of the driveway and slid down to the bottom of the driveway and landed in a ditch. I asked Mr. Literal if he would consent to standardized field sobriety tests, and he refused all sobriety tests. He stated he also refused to a portable breath test. When Mr. Literal spoke, his speech was slurred. I also observed his eyes to be bloodshot and glassy. The strong odor of an alcoholic beverage was also emitting from his person. I asked Mr. Literal if he consumed any alcohol, and he stated he had been drinking. Mr. Literal was cited for OVI under 45-11-19A1A. He was then released to his father upon an HP 60 release form. The motorcycle was on private property and towed at the request of the property owner. And that's the end of the report.
All right. Anything you want to say in response to that, or otherwise you have a right to make a statement of explanation or anything else you want to say to the court before sentencing?
I've turned my life around since then, Your Honor. Like I said, I went through nursing school, and that's really all I have to say, sir.
Okay. Well, my standard procedure, I don't see any reason to deviate from it here, and actually there's 4 years worth of reasons to stick with it, is I'm going to give you a $1,000 fine. If you refuse to take tests, my standard procedure is give a $1,000 fine on that. So I'm putting a $1,000 fine. Order you to pay the court costs. 6-month license suspension, that started the day of the incident. 30 days in jail, 30 days suspended. 30 hours community service, 2 years of level 4 probation. He's required to go to the driver intervention program. The hearing will be April 27th of next year, 26th. You'll need to meet with Mr. Major in probation.
That's right.
Give them, then come back for that probation now. Yes. Thank you, Judge. Thank you.
State of Ohio versus Shelby Frazier, case number PRG 252357, it's going to be in
This is Mr. Steyer's case with pre-trial.
Your Honor, this matter is an OVI with a urine screen. As of this morning, the state advised they don't have the test results, so I would assume that they're going to be moving for a continuance.
We will need to do that. Now, this stop was on, let's see, it's a different case. Let's see here.
The citation was September 9th.
So we've got until the early part of December for the 90 days. So we asked maybe for about 3 more weeks.
That's November 10th.
I have a jury trial November 10th, but I am here the 17th, Your Honor.
Okay, that's fine, November 17th. pretrial, 10 o'clock.
State of Ohio versus Evan Willard, case number CRB 25-422, A and B. It's on Zoom now.
Mr. Willard, can you hear us?
Hearing by teleconference. Mr. Willard, are you there?
Yes, sir.
And Your Honor, Mr. Willard is a resident, I think, of Columbus, but he also works on the road further from Columbus, and he wasn't available to make it down here today. I wasn't able to necessarily secure a continuance, but I told him to at least be here by video, and we'll try to make a new hearing date for that. We discussed the matter this morning. I've got an offer from the state, the same offer I think I've already given it to Mr. Willard. So at this point, well, just to repeat it, Mr. Willard, the offer is 60 days in jail, suspended anger management, probation, and a no contact order with the alleged victim of the menacing case. If you're agreeable to that, we would probably need to come, I would assume the court doesn't want to do that by video. So either we either need to have you back here in person to enter that plea, and if you're not interested in that plea, we may need to set a trial date also, which you'll need to be here in person. So kind of, you can guide me on whether you think you're going to take that offer, or whether you'd be interested in a trial.
Yeah, I'll take the offer.
Okay, so we need to make a date then to be back here. Do you know when you're going to be physically available to get down here?
I heard you say the 17th, I could do the 17th.
I'm here the 17th, Your Honor.
Okay, the case will be set November 17th for a plea and as a pretrial.
And Your Honor, I'm sorry, Mr. Will, we do need you here in person that day.
10 o'clock.
Yes, sir.
Thank you.
State of Ohio versus Kayla Harris, case number PRD 21-1692, CRB 21-209.
Skyers case.
Okay. What we've been working on here, Your Honor, is for Ms. Harris to get her driver's license back. One of these cases is an old driving under suspension. She has, I guess, found out that there is a hold out of Proctorville, which I assume would be Mayor's Court. I don't know exactly when that meets, but I think she at the very least need to go take a look at that. I'm not sure if the court wants to continue to give her time to work on the license or.
That's fine if the state's agreeable. There should be a clerk there during the day she could go talk to about what needs to be done.
And don't always have the best of luck with that. If you try a few times, you usually catch somebody eventually.
We're not opposed to it with respect to the driving under suspension charge. This other case number, 21 CRB 209, A and B,
These are also post-conviction.
well, I wanted to make sure that that was the case, because I don't have.
I have a judgment entry on that.
Okay.
Filed July 23rd of 2021.
All right, so we're okay with a continuance with respect to her getting her driver's license.
How much time do you think you need?
As a practical matter, Your Honor, I think we probably ought to go a little further, maybe the 24th.
November 24th?
To write that down.
November 24th for pretrial will be the next hearing, 10 o'clock.
Thank you, Your Honor.
Thank you for that, so you have the information.
All right.
State of Ohio versus Christopher McMillan, case number TRC 25-1925, A, B, and C.
You may recall, Your Honor, that I talked to you, Mr. Hill, by text this past week about Mr. McMillian, and he needs a continuance. We went and left it on the docket so that we could get a date that worked for everybody instead of just picking one out and maybe having problems. So, and we will waive time constraints to accommodate it. I don't know what sort of a time frame. I'd say a couple of weeks. What happened is his son suffered a pretty serious injury and has to have someone there with him around the clock right now. So he wasn't able to get somebody there with him today. We go a little bit further out, he can maybe either have like skilled nursing involved at that point or just have time to make arrangements to get coverage.
How about November 3rd?
I'm available.
November 3rd at defendant's request is the next hearing for pre-trial.
State of Ohio versus Danny Sellers, case number CRB 25512, CRB 24504.
Mr. Steyer's case pre-trial.
Your Honor, I've gotten an offer from the state, which I have communicated to Mr. Sellers. He is not interested in that offer. I have received discovery in this matter. I want to make arrangements to go over that with Mr. Sellers. So I think we need to come back again. Do you think you can get over to office before the 3rd?
Absolutely.
Okay, so what I'd like to do is maybe stick with the 3rd on this one, and I'm going to make arrangements with Mr. Sellers to come to the office and take a look at the discovery.
Okay, case will be continued to November 3rd at defendant's request.
Text me, we'll figure out the time to meet. Okay.
All right.
Thank you, Your Honor.
Thank you.
State of Ohio versus Jason Taylor II, case number CRB 2524, A, B, and C, PRC 172266,
Mr. Steyer's case.
Oh, that's what you're saying.
It's a good report.
And Your Honor, there is a matter of, I'm sorry, restitution in this case. Mr. Taylor had hoped to have the full amount today. He does not have the full amount, but he does have $500. I'd like to see if we can go ahead and have that deposited with the clerk, and then he can come up with the rest on another date.
Okay.
But I think we may need an entry to allow that. I don't know, do we in fact need an entry?
Let's do one, just in case we'll have a record of it. The court will accept the partial payment of restitution of $500 today, the balance, you know, the balance is right before we come back. Well, it has to go through the clerk's office, so. How's he gonna pay it?
Is it cash?
Cash.
He's got cash.
Okay, we can give him a receipt.
And Your Honor, he indicates that his next paycheck will fall shortly before the November 17th date we've been discussing. So he's asked if he can be put back on that date so that he anticipates he can have the rest of the restitution that day.
What's the balance?
It'd be 705.
Total?
Yeah, it's 1205 minus 500.
So
let's do an entry today saying he's paying $500 in cash, so go as a partial payment of restitution. He'll pay $705 by the next hearing date.
Okay, I'm still looking at that case number. I don't have it with me.
2524.
What was the balance?
Balance is 705. Before or on November 17th, which will be the next hearing date.
that's paid, does he have to come back? Yes. So it has to come back. But if it's paid before we get here, that's better.
Yeah. Right.
Okay.
Who's the restitution going to?
Mr. Hill, who's the
Charles
recipient?
Stewart?
That is correct. Well,
There's also criminal damaging of Adam Bryant. So I'm not sure which one.
I think Mr. Bryant is
It is.
the recipient of the
Adam
restitution.
Bryant.
Yes.
Okay, Adam Bryant.
Sorry.
Okay, November 17th will be the next hearings for Mr. Taylor.
Go on out there, then they can wait a little while before they have a file. You may be able to just go ahead and do that. 10 o'clock. 10 o'clock. Go to the clerk's office.
Yeah,
but you have to wait a couple minutes.
Okay, that's fine.
Thank you.
State of Ohio versus Tyler Young, case number CRB 25509.
Tyler Young, pre-trial 25509.
You may recall this matter, Your Honor, is one where the defendant is getting medical treatment in the state of Virginia. I have not gotten an update on that recently, but that was the last information I had. My communication has been through the defendant's mother, who is also the alleged victim on this matter, and who is supportive of the treatment. At this point, I'm going to ask for a continuance. If we maybe set it for the 3rd, and I'm going to try to get a more solid report on what's going on. I don't know the actual name of the facility he's treating at.
Excuse me, Mr. Hill.
We're okay with that, Your Honor.
Defendant's request case is continued to November 3rd to get more information about treatment for the defendant.
State of Ohio versus Evan A. Jones, case number TRC 252411, A and B.
All right, Mr. Jones, do you have a lawyer representing you today?
No, sir, I came back today to change my plea.
Okay, so you're going to proceed without a lawyer then?
Yes, sir.
You want to change your plea?
Yes, sir.
What do you want to change your plea to?
I want to change my plea to non-contested.
Okay.
Now that I understand everything that's going on, I changed my plea to non-contested.
Okay, so no contest means you're not fighting the charge.
Right.
You're not admitting it's true, but you're not denying it either. And you agree by entering a no contest plea that the court can find you guilty if I believe what the state says it has as evidence is legally enough to convict you. You're saying, I'm not going to put up a fight. Judge, if you think what they have is enough for a conviction against me, I agree you can find me guilty without a trial, without me having a lawyer. Is that what
Yes,
you
Your
want
Honor.
to do? That's what you want to do?
Yes, Your Honor.
Okay.
Case number?
Case number is 252411. I do not. I do have an officer statement. Okay. So I'm going to go ahead and read the officer statement into the record, and then if you want to make a statement, you can. You don't have to.
Yes, sir.
The officer says, September 14th, 2025, I was dispatched to a crash on US 52, County Road 1 in Perry Township. When I arrived on scene, I observed a vehicle off the right side of the road that had struck a guardrail. Deputy Chin was there and gave me the driver's license and identified the person as Evan Jones. Made contact with Mr. Jones, who was in the back of an EMS squad, and asked him what happened. He stated his brakes failed and he got scared, so he crashed into the guardrail. While talking to him, I noticed his pupils were pinpoint, and I could smell an odor of alcohol coming from the squad car. His demeanor seemed to be lethargic. I processed the crash scene while EMS was doing their check on Mr. Jones. Mr. Jones was released by EMS, and I had him walk back to my cruiser. While at my cruiser, I asked him what happened, and he said he hit his brakes too hard because he missed his turn. As I began to talk to him, I asked if he had consumed any alcohol that day, and he said he did not. I asked him if he had used any drugs. He said he had not. Moments later, he said that if I tested his urine, it would come back with marijuana in it, and he did in fact have one beer earlier. At this point, I had him perform field sobriety tests. I could continue to smell a faint odor of alcohol coming from his person. He stated, in fact, he had smoked marijuana 2 hours prior to the crash. Had him do a cortisol gaze and nystagmus test. The odor of alcohol beverage began to smell stronger, and his eyes were bloodshot. While explaining the instructions, he was advised not to move his head. While performing the exercise, he moved his head repeatedly, was having a difficult time tracking my finger. The second exercise performed was a Romberg test. Asked him to tell me how the crash happened, stopped him, told him I did not. Asked him to tell me. He first attempted to tell me again how the crash happened. I stopped him, told him I did not. Ask him to tell me how it happened. I wanted him to estimate the passage in 30 seconds. I had him do that, and again he started telling me how the crash happened. And this happened 3 times according to him. It was clear he couldn't follow instructions. Walk and turn test. There were validated clues on the walk and turn test and on the one-leg stand test. He declined to give the breath test. He was released to his girlfriend. And on the walk and turn, he says there were 7 of 8 clues, 3 or 4 clues on the one-leg stand. Okay, any statement or explanation you want to make, Mr. Jones?
Yes, sir, Your Honor. I just want to say that this wreck has changed my life. Personally, character-wise, this is not me. It wasn't me. When I walked away from this wreck, I shouldn't have. But the Lord gave me a second chance, and since then, I've been trying to better my life. I've looked into options for schooling. My employer has also reached out and tried to help me for schooling, and I've quit drinking. I haven't had a drink in 30 days.
Okay, that's good.
Been cold turkey.
What do you do for,
I work for McDonald's.
okay.
I do maintenance. I go anything from deep fryers to hosing the lot, fixing some small equipment, sweeping the floors.
Which one, you work for Mr. Seelig, or which one do you work for?
It's not Seelig no more. It's still Seelig, but it's his daughter Melissa.
Okay.
Yeah.
Why would you not take the breath test?
I honestly don't know, Your Honor.
Okay. You said that you refused to take the breath test, so, I'm gonna give you a $1,000 fine on that. That's my policy. If you refuse to take tests, I'll give you a $1,000 fine. Because we all sign something when we get our license saying we will take tests if we're asked to.
Yes, sir, Your Honor.
Or you pay the court costs. 6-month license suspension, that started the day of the incident, September 14th. So it's going to run into March, and but it's not self-correcting. So when the suspension is up, which it will be in March, you have to contact the B&V and get reinstated.
Yes, sir.
They'll make you pay a reinstatement fee. You did have proof of insurance, that's good. 20 days in jail suspended. I'll suspend all your jail time on the condition that you do 5 days of community service on our community service program.
Yes, sir.
You do it on your days off. What days do you have off? Do you have a
I
regular
have
schedule?
tomorrow and I have Tuesday and Wednesday off, Your Honor.
Every week or just
Every
Sundays?
week.
Every week, okay.
Yes, sir.
Well, that works. We have community service both those days. So you can get get it done without interfering with your job. You have to go to a driver intervention program.
Yes, sir.
That's a 3-day program that you have to go stay to, or if you don't do it, I have to make you go to jail. So you'd
I'll do
rather
it.
go to that than go to jail.
I'll do it.
Okay, so talk to your probation officer about it. He'll give you the details. There's one here in Lawrence County, but you don't have to go to the one here. There's one in most counties, but the big counties have multiple ones, and they all don't charge the same amount, so.
Right.
You can pick out one, as long as it's approved by the state of Ohio, when you go to it and
Okay.
complete it, then that'll satisfy. The only thing about going to the one here, I know they will notify the court and send the paperwork in. If you go to one in Toledo, I don't know if they'll send the paperwork in or not. It's up to you to make sure.
Right,
everything gets
well,
filed.
I can't afford to go to Toledo, Your Honor, so,
Okay, well, I was just using that example. I know the one in Chillicothe is a lot cheaper than one here, so that's up to you where you go, but you have to go to one and complete it.
right.
Okay, on the failure to control, a $20 fine. And that's it. So you're going to go talk to Mr. Major, he's your probation officer. His office is to the left. as
This
you
one?
leave. Yes, on that side of the building. Go talk with him. Your review hearing date is April 27th
April 27th?
of next year.
Next year.
And I usually say this earlier than I am today, but there's no excuse for not knowing what you're supposed to do because, one, there's clerks here, and they love it when people call and say, I forgot what I was supposed to do. Can you look it up and tell me? They love to look up stuff and tell people what they're supposed to do. And also, you have a smartphone, don't you?
Yes, sir.
Everybody has a smartphone, and you can get on the internet with your smartphone.
Mm-hmm.
We have a website, Lawrence County Municipal Court. Google it. You put your name under record search, your case comes up. It tells you when you have to be back and what you're supposed to do. So there's no excuses for not knowing what you need to do.
I got you. So April 20th, Your Honor?
27.
27th, thank you.
He's going to give you a piece of paper that's got it on it, but
Okay.
if you lose it, because I have people that get arrested because they didn't come there, they say, well, I lost my paper, I didn't know what I was supposed to do. That's not an excuse.
All my important papers normally go in my wallet.
Okay, go see Mr. Major, you're free to go after that.
All right.
That's all.
State of Ohio versus Jacob Richter, case number CRA 25648. Your Honor, he has been picked up by Pickaway County.
All right, this was a Rule 4 to Pickaway County, he has been picked up, so the case here can be dismissed.
State of Ohio versus Christopher Harper, case number CRB 25672.
So this is for arraignment.
Yes, sir.
And sir, you're Christopher Harper.
Yes, sir.
You've got one charge, criminal damage. And were you here when I explained the rights of defendants?
Yes, sir.
Okay, do you have any questions about your rights?
I just have a couple questions about the charges. I'm not from here.
Okay. Do you want me to go over your rights again with you, or do you understand those?
Yeah, I understand.
Okay, I'm going to go over the charge with you.
Yes, sir.
The charge alleges that on October the 18th, Fayette Township, you knowingly caused or created a substantial risk of physical harm to a door that was the property of, it says Airbnb. I'm assuming somebody else owns it, I don't know. But that's what it says. That's a second-degree misdemeanor, maximum penalty, 90 days in jail, $750 fine. Do you understand the charge?
Yes, sir. From my understanding, the owner of the property wasn't gonna press charges. I was gonna pay for the damages, and no charges was gonna be pressed.
Well, I don't know anything about that. All I know is what's in front of me, and it's a complaint, so you've got to proceed. Somebody did file the charges. They got them filed today.
Okay.
So So I take it from that, you want to enter a not guilty plea?
Yes, sir.
Okay, I'll enter a not guilty plea for you. You want to be considered for a court-appointed lawyer?
Do I have time to think about that? You can just put me down for I'll get my own lawyer.
Okay, so you want to hire your own lawyer?
Yes.
And the address listed is Louisiana?
Yes, sir.
So do you want some time before you have to come back, or when? Or you
I
want
would
to come
like
back quick?
to, I would like to come back as soon as possible, like, because I'm not from here, I'm on a job,
Okay.
and it was just a disturbance between me and a friend, and it kind of just went a little too far.
Well, let's set it next Monday, and it gives you a little time to get a lawyer and come back. How's that?
Okay, the jail time,
That's not mandatory, it's just, that's the maximum. 90 days in jail is the maximum you can get.
okay, all right, and it's just a
9 to 0, there's no.
yeah, it's just a misdemeanor, and, what's the charge like, I mean, like the fine like on that?
Well, $750 is the maximum. You go
700?
from 0 to 750.
Okay. All right,
You want to hear, I don't know if the prosecutor's in a position to give you an offer. You want to give an
Yeah,
offer on this?
yes, I would love it.
Well, Your Honor, I don't know what the restitution's going to be, and just to clarify about the Airbnb, obviously that's not an individual's name, and that's not even a property name, that's a business that some people run. And it's my understanding, and I don't know this yet confirmed, but the owner of the particular property, it is an Airbnb property, and it's the gentleman that owns
Rented
it.
through Airbnb?
Pardon?
It's being rented, it was rented through Airbnb?
Yes, and apparently it's the gentleman that owns the Casa Grande, that owns the property. So we got to get that particular information. So there might be restitution. Also, Your Honor, I believe we presented to the court earlier today an entry to allow the release of a lady named Renata Brown from jail because we weren't going to charge her. We were considering a cross domestic violence charge between her and Mr. Harper, which we decided not to file on either. So that's the context that this happened.
And she did get released, she's here.
And she's here, she got released. So apparently there was some damage done in the apartment or the house or whatever during this situation. So we're going to need to know if there's restitution due.
You can have that by next Monday, I understand.
We will certainly make every effort.
Excuse me, if I may, if y'all not going after any jail charges, I'll plead guilty and pay the fines right now.
Well, we don't know the restitution amount. We'd still have to come back at a later date to do that.
Yes, sir, I understand.
Now, here's the thing, the report didn't come with anything more specific than Airbnb. So we have some...
I got that information from the girl we didn't charge.
Yeah.
Who owns it.
Oh, you do, okay, so we could even try, do we have the ability to try that today, you think?
I can call some.
We can try to figure out,
I don't know if they got.
get to the
this.
owner and find out if there's a restitution figure, if he wants to wait around today.
If you want to wait, we'll put it at the end of the docket, let them call the owner, see if he has an amount that he wants to fix the
Yes,
door, and then maybe we can resolve it.
Yeah, if I can get it done today, yes, I would.
Just have a seat, we'll call you later in the docket.
I appreciate it.
Your Honor, we're ready to take some inmates for the lunch.
Okay, we've got inmates here from the jail, we're going to start with their cases.
State of Ohio versus Joseph Hardwick, case number CRA 25663.
Sir, are you Joseph Hardwick? Mr. Hardwick, you have an extradition warrant filed against you. I'm Judge Capper. I'm going to be handling the extradition. So I'm going to go over your rights, but you have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make Kentucky and Ohio prove that these charges are valid and apply to you. Do you understand those rights? Yes. The allegation is that you have a warrant issued by Kentucky, Boyd County Circuit Court for receiving stolen property, possession of a controlled substance, and contempt of court. So you have a right to an extradition hearing, you have a right to have an attorney appointed for that here. The hearing here would not be whether you did those things. The hearing would be, is there good cause to send you to Kentucky on these charges?
Yes.
So.
I'm just going to waive extradition, go ahead and sign extradition.
All right. So I've got a waiver of extradition. I put an X there where you need to sign. It just says I'm waiving the right to the hearing and requesting that I be returned to Kentucky. Okay. The court over there says no bond. But I think on these kind of charges under Ohio law, I have to set a bond. So I'm going to set a $25,000 cash or surety bond. So what that means is if you got $25,000 that you want to post with the clerk, or you go turn yourself in, as soon as you do that, it'll be released, you get the whole $25,000 back once you turn yourself in to Boyd County Circuit Court. If you can't do that, I'll let you use a bail bond. You pay them a fee, usually it's 10%. So $2,500, but you lose that fee, that'll order you to go turn yourself in. If you can't do either of those, I'm going to order Boyd County to come get you. Now the good thing is they're close, usually within 2 or 3 days they come and get people that I order to pick up. So how do you want to proceed? You want to try to postpone, or you want me to just order them to come get you?
Order them to come get you.
Okay, that's what I'll do.
How long will they have to be?
I'm going to set it for another hearing in a week. And if you're still in the jail, I'll deal with you then, but in my experience with them, because they're so close, if you're still in our jail in a week, something went wrong. Somebody didn't talk to somebody didn't call somebody, and you're sitting back there. That's why I'll set it for a hearing. I don't want you to sit back there and not be taken care of. 95 times out of 100, you'll be over there in just a few days. So. Any other questions? Okay, that's all.
You're welcome.
State of Ohio versus Justin Higgins, case number PRC 252689, CRD 213577 A and B, CRA 21911, CRB 2397, CRD 2911.
So on that last guy, Mr. Murray, put him on my docket for the 27th at 10 a.m. In Kentucky can be notified he's eligible to be picked up immediately. And they have to pick him up before 8 a.m. on the 27th. Sir, you're Justin Higgins. All right, Mr. Higgins, you've got a new charge. And I think, it looks to me like Mr. Morford is representing you on an old case. It appears to still be pending. Is he still here, Mr. Morford here?
Yes, I believe so, Your Honor.
Okay, let's have him come in. Mr. Morford, this is your client, Justin Higgins, He has a case pending that's set for pretrial November 10th, but he's got a new charge. So this is his arraignment. It's 25-2689 and 25-667. 25-667 is an aggravated possession of drugs charge. It alleges that Mason Township on October the 18th, Justin Dale Higgins knowingly obtained, possessed, or used methamphetamine, Schedule II substance, possession of which is a felony of the 5th degree. Maximum penalty is a year in jail, $2,500 fine. Then there's a traffic charge, 25-2689, alleges October the 18th at 6:33 p.m. in Mason Township. Mr. Higgins is alleged to have been driving a vehicle under the influence of alcohol or drugs or a combination, that he submitted to a urine screen. Of course, the urine screens take a while to get the results, so I don't have any results yet on that screen. It's alleged this would be his first offense, so maximum penalty 6 months in jail, $1,075 fine, 3-year license suspension. And he's also charged with driving without a license. It's a first-degree misdemeanor variety, and failure to use the turn signal. So, I'll point you, Mr. Morphy, I think you were appointed on these, on the new charges. What's the state's position on bond? And there's also other charges still pending for, they're for review. He has a DUS from 2020.
He's got a case from 2021 that is pending also, Your Honor.
There's a fictitious license from 2020. There's a wildlife violation still pending, looks like. It was concluded, but he hasn't paid it. And then there's one from 2017.
We've also got 21 CRA 911, which is a receiving stolen property, which we set for.
Yes, 21-911?
Yes.
Okay, it's still pending?
Yes. And we are scheduled to come back on November 10th on that one, and we were going to try to find out some information about the truck, what happened to the truck, whether there might be restitution in that case. But in this, Your Honor, the possession of drugs and the OVI together are very concerning to us, and if Mr. Higgins, our recommendation would be that if he would be agreeable to checking into treatment, being assessed for treatment, and agreeing to follow through with the recommendations, that we'd be okay with no R bond. But otherwise, we would want a cash or surety bond.
With or without ankle monitor?
Well, maybe with ankle monitor.
Okay, does he have a medical card? Ohio, or you Ohio resident? Okay, you want to talk with him, and I'll have someone talk with you, and we'll come back. I'll give you the court's files, Mr. Moore, if you want to talk with him about these matters, and get him assessed. We'll come back and set bond after that happens. Thank you.
State of Ohio versus Thomas Lewis, case number CRB 25669.
Sir, are you Thomas Lewis?
Yes, Your Honor.
Mr. Lewis, it's alleged that at Union Township on October 19th, you recklessly entered or reigned on land or premises of another, which you had noticed was unauthorized access or presence. That is criminal trespass. It's a 4th-degree misdemeanor, maximum penalty 30 days in jail, $250 fine. understand the charge?
Yes.
How do you plead to the charge?
I plead not guilty.
You wish to be considered for a court-appointed lawyer?
Yes, Your Honor.
All right, Mr. Stratton, I'll appoint you.
Yes, sir.
Not guilty plea is entered. Any objection to an OR bond?
Your Honor, I'm sure this doesn't look more like a burglary. We would ask for a $2,500 cash assurance bond.
Your Honor, I don't think that's on. I can't, I'm a daughter of home. My daughter is home now. So the past home job with my daughter is my concern. If I can do the war on, I don't have money for a cash assurance. She's in school.
Yeah, let me read the affidavit. Okay, is there going to be drug paraphernalia charges? I just read the affidavit. It sounds like there was some found in the vehicle.
We will likely do that.
Yeah, I'm a little confused about the recommendation because it's a fairly small charge.
It just appeared to me that it looked more like an attempt to enter the residence. But if that, we understand the court's position on that.
Well, I'm going to let him sign an OR. That's $2,500 OR bond. Not guilty plea is entered. So I remember you're not available the 3rd.
November 3rd, 10th, and 24th.
7th, then, November 7th. November 7th at 10 o'clock for the next hearings.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Jared Ray Meredith, case number CRA 25543, CRB 2462, PRD 22920, PRD 221036A and B, PRC 202206, CRB 19756.
And you're Jared Ray Meredith. Okay, you've got a new charge, 25,543. Failure to comply with the order signaled by the police officer. You have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove this charge beyond a reasonable doubt. Do you understand those things? This is an older charge, but within the last few months. It's alleged this happened on August 26th of this year in Fayette Township, that you did operate a motor vehicle so as to willfully elude or flee a police officer after you received a visible audible signal to bring your vehicle to a stop, and that in the operation of your vehicle you cause a substantial risk of harm to other people or their property. So that's a felony of the 3rd degree. Maximum penalty is 5 years in jail, $8,000 fine. You understand that charge? Then you also have the case is still pending. Mr. Stratton was your lawyer. So last year was set for a pretrial July the 11th. CRB 2462. It was a domestic violence charge. It's still pending. So as you failed to appear for a pretrial July the 11th of this year, there was also traffic 22-920. So driving under suspension, that was set the same day that you failed to appear. There was one from 2022, 22-263, and 22-1036 also set. July the 11th. And then there was an old OVI, 20-2206. Failure to comply. 19-780 was a aggravated menacing. Mr. Stratton, this was your client. He allegedly missed a hearing back in July on some couple pending charges, and he's got a new charge. So I will appoint you on the new charge. State's position on bond.
It's alleged that Mr. Meredith was fleeing the police at speeds of over 100 miles an hour. So, I mean, it's a pretty serious situation, and it involves trying to escape the police and being put in custody. So we'd ask for a $10,000 cash and surety bond.
Any postal bonds? Bond will be 10,000 cash or surety, and that'll cover all the pending cases. Need to have it in pretty soon, since looks like he's not getting out. When did he come into custody? Lawrence County Jail. When did you come? Okay. Yeah, we can set it for the 24th. $10,000 cash or surety. October 24th, for all of his cases, will be the hearing date. And maybe that can happen on Friday. I don't know about treatment. It would definitely have to be with the GPS monitor.
People wouldn't know that. It's not listed underneath their name on Airbnb. I got you. I'll tell you, they're going to be talking about this today. His wife is scared of the properties.
State of Ohio versus Jessica Morrison, case number CRA 25664.
I'll have to get when she calls me back. He left her, he's going to tell her to call me. And I'll get all that information.
Are you Jessica Morrison?
Yes, sir.
I'm Judge Kapler. This is a arraignment hearing for you. The charges are actually in a different jurisdiction, but in Ohio, if there's charges against you in a county that doesn't touch, contiguous is the big word, if it doesn't touch the county that you're found in, you have a right to hearing to make sure we're not sending the wrong person to that county. Your charges are in Meigs County. And I've got a copy of an indictment from the Common Pleas Court in Meigs County on 2 counts of possession of drugs. Both are felony files. You have a right to have a hearing here to make sure you're the right person and that I should send you to Meigs County on these charges. You can have a lawyer, you can have one appointed if you can't afford one. You can waive, it's called a Rule 4 hearing. You can waive your Rule 4 hearing and say, I agree to go to Meigs County, and we won't have that hearing. You'll just go there and face the charges in that county. How do you want to proceed? You want to have a hearing here, or do you want to just go to Meigs County?
Okay, so, I mean, I want to get it done as fast as possible. Like, I don't even know where these charges come from. I've been in sober living for 10 months. Like, I've got a full-time job. Like, I'm trying to get out so I can get to work. Like, I have no idea what any of this is.
Okay, well, these are all the charges. These charges were filed in Meigs County, February the 15th, 2018.
Yeah, I've been pulled over twice in the last month here, and nobody's ever said a word about it. I've had the police at Speedway, because I have to call the police, you know me, and they run my name and nothing's ever popped up. So like, this is just weird to me.
Okay, it can be weird, but I've got a copy of the indictment and I've got a copy of the warrant, so.
It's fine, just, I just need to get there as fast as possible.
Okay, so you want to waive the Rule 4 hearing and have Meigs County come get you?
Yes.
Because they have 56 Penny Lane, Point Pleasant, West Virginia is your address.
Yeah, I've been there 12 years or longer.
Okay. If you can you post any kind of bond?
I've got $500 in the post right now.
Okay.
Actually, that was part of my tag money to get my car fixed, but it's fine, I'll do whatever I need to do. If I could do 250 would be great. I gotta be at work at 2 o'clock, so.
Well, I don't think that's going to happen.
But I'll take.
Here's what I'll do. I'll set your bond at $2,500. cash or surety. So it doesn't sound like you got $2,500 in cash, but if you did, you can pay it to the clerk. You turn yourself into Meigs County, you get all $2,500 back. But I'm gonna let you use a surety also, so that's a bail bondsman. You can use a bail bondsman. You pay them usually 10%, so $250 probably gets you out, and you can go turn yourself in Meigs County. Here's the thing about bail bondsmen, if you use the one that 95% of the people use here in Lawrence County, Mr. Sowers, he's really good about getting there fast and taking your money and getting you released. But if you don't show up, he's also fast about tracking you down, throwing you in the car and taking you to the jail.
Well, I'm in sober living, so they'll get me where I need to go to turn myself in.
What's sober living in?
I'm in United Family Recovery.
Where's that? Oh, United Family
Yeah,
Recovery, okay.
right.
I got that.
But you start
I
to
didn't
go-
understand what you said at first, okay. Yeah, we work with them. Okay, so you think you can post that bond?
Oh, yeah.
So you want to talk to Mr. Sowers, or you want to talk to the
Yes, please.
fastest bail bondsman, all right?
Yes.
That's definitely him. So I'll give you till today to post it.
Hopefully next car, because that's all I have on my phone right now. If not, I'll have someone do it for me.
Okay.
You can let me how long I have to go to school.
So he did get away.
No, I can't do that.
We'll figure it out.
Once you get a bond posted, I'll let you out. But I'm going to order you go turn yourself in. I'll give you a week. If you post the bond, turn yourself in before October 20th at 10 a.m. So if you can't do that, if you can't get to Meigs County, you know where Meigs County is, right? Okay. Okay, October 27th. If you can't get there, you got to show up here next Monday, October 27th, and explain why you couldn't get to Meigs County.
They'll make sure I get it.
Okay, so this is, you're going to sign this, and what I've added, in case you can't read my handwriting. Defendant is to turn herself in to Meigs County Court by October 27th, 2025 at 10 a.m. or appear back in this court and explain why she couldn't. You understand what you got to do?
Yes.
And I set your bond at $2,500 cash or surety to be posted today. Okay, I need an X where you need to sign. And I would suggest also when you go up there, take some documentation as to your treatment and recovery. And I think, I can't speak for that court, but I know what courts do. They're probably going to just order you to go back into treatment. They want to see you get clean. So
I've been clean for 11 months.
So that's what I would suggest you do. Take some good evidence that you are in treatment and making good progress toward recovery. Or be back here next Monday at 10 a.m. and explain why you didn't get up there. You understand?
Yes.
Okay.
Do you have a number I can call to get this dog appointment, or are you just going to send it to?
Mr. Cooper's probably already texted him. Or is texting him now, so. All right, that's all.
State of Ohio versus Richard J. Riggle, case number CRB 25668, A and B.
Okay, so yeah, no, we don't have it, so I so I didn't catch that later.
So are you Richard Regal? Yes, sir. Mr. Regal, it's alleged that in Fayette Township on October the 18th of this year, while being under the influence of alcohol or drugs, you used a firearm or dangerous ordinance while intoxicated. The charge against you is using a weapon while intoxicated. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge? You have a right to remain silent. You don't have to say anything. If you choose to make statements, they can be used against you. You've just been handed a copy of the charge. You have a right to bail, to make the state of Ohio prove this charge beyond a reasonable doubt. You understand those things? Okay, do you have any questions about your rights? You have a right to an attorney to have one appointed if you can't afford one. You understand that?
I asked you to attorney, I would like to just
Sure.
explain exactly what happened.
You want to be considered for a court-appointed lawyer? Are you working?
I am working, yes.
What do you do?
I'm a decade over American Petroleum.
You may make too much money to get a court-appointed lawyer. I have to ask you about your finances.
I haven't even got my first paycheck.
Oh, you just started?
Yeah, I just started. I am in rehab. I actually got a hold of.
Which one?
Right now, I was going to PROACT. I graduated from PROACT, and now I'm going over to Canova, Sun Environmental Contemplations. And I'm actually requesting if there's any possible way to do inpatient healthcare through that. Outpatient has been moved to work with me. And my job's going around that as well.
Mr. Steyer?
I'm here, Your Honor.
I'll appoint you to represent Mr. Regal. He hasn't received his first paycheck yet, so he's qualified. Entering a not guilty plea. Why don't you talk with him, and let's discuss bond after that. He's interested in going to inpatient treatment, you just said.
I'll talk to you. Thank you, I'll speak to him.
He's a deckhand with Marathon. Just started that work. We'll call you back after you talk to the lawyer and decide what your bond will be. Yes, sir.
State of Ohio versus Derek Lockhart, case number CRA 25659.
You were looking for a GPS monitor for Mr. Lockhart, right?
Yeah, we actually, after court today, I'm going to bring it.
Okay.
May I pass through, Your Honor?
Sure, yes. So RRS will take Mr. Lockhart with the GPS ankle monitor. We believe there is one available.
Yes, sir, there is, yeah.
Chelsea Lockhart.
Anything you want to say, Mr. Morgan?
No, Judge, we're in written.
Okay, so we just need to set another day.
Yes, Judge.
November 3rd. November 3rd will be Mr. Lockhart's next hearing date in this court, 10 o'clock. Okay. Good luck. Take advantage of this opportunity.
State of Ohio versus Charles Ritchie, case number CRB 25662, CRB 25165.
This is Mr. Stratton's case.
You were set down two charges. Sexual abuse charge, criminal damages charge. To plead to the criminal damages charge today. Spend the time on that. And then we're going to some execution. But as for the sexual position charge, we have to have the second file.
Okay. So that's 25662. have, well, I know you have dates in November where you're not available.
3rd, 10th, and 24th.
Does the state have any input on trial dates?
Any Mondays. Whatever the court's pleasure.
You said that you couldn't do the 17th.
I can just,
14th or 17th?
forget
14th, okay, would you say, for trial?
Yes, Your Honor.
Okay, November 14th will be the trial date.
You want to hold off on sentencing on criminal damaging for the appointment also?
Yeah. So we'll set the 25-165 for sentencing that day, and then also.
Court, we consider law on this case for Mr. Chief.
It's set at 10,000 cash for shooting.
He's going to make that bond, Your Honor.
You have a bond that he could make?
There's a bond today.
Okay, well, I'm not gonna change it then. November 14th at noon will be the trial date.
State of Ohio versus Willard Starkey.
Charges have it. It's not
Case number CRB 25671, CRB 25666.
For arraignment? Sir, are you Willard Starkey? Mr. Starkey, I'm Judge Capper, and we'll go over your rights with you. You have a right to remain silent, you don't have to say anything. You have a right to have an attorney, have one appointed if you can't afford one, to have bail, and make the state prove charges beyond a reasonable doubt. You understand those things?
Yes, sir.
You've got two matters before the court. One, it's alleged that there's a warrant for your arrest out of Cabell County Circuit Court, Judge Howard's court. And they're asking that you be extradited to West Virginia on these charges: domestic violence, fleeing and eluding, and escape. So you have a right to have an attorney on that. And you've got charges here in Lawrence County, possession of a drug abuse instrument. And that alleges on October 17 of this year, in Fayette Township, you knowingly possessed an instrument used to administer dangerous drugs, being a hypodermic and a spoon. That's a second-degree misdemeanor, maximum penalty 90 days in jail, $750 fine. So, you understand the matters before the court?
Yes, sir.
Do you want a lawyer appointed to represent you?
Yes, sir.
Do you have a job? You have no income at all? I'll appoint Mr. Morford to represent you. State's position on bond?
Well, I think probably the extradition, the bond on that probably takes precedent. What I would say to Mr. Starkey is that if he entered a guilty plea to the possession charge, we'd ask for the sentence to run concurrent with whatever, however much time he has to spend here before he's released to West Virginia.
So you can go immediately to
To
West
go,
Virginia.
yes.
So you want to talk to him about that, we'll come back and decide if that's something he wants to consider and get court's files with you. Okay, we'll do call it later in the docket. I'm going to let you talk to your lawyer, and then we'll come back.
State of Ohio versus Eric Williams, case number CRA 25665.
You don't plead.
Okay, I guess that's what I did. All right, Ms. Williams, you've got a warrant allegedly entered against you by Boyd County Circuit Court, Boyd County, Kentucky. It's on a probation violation. And they want you extradited on this to their state. You have a right to have an attorney appointed here to represent you and to have an extradition hearing. You don't have to say anything about this. You have a right to remain silent. You have a right to have a lawyer appointed if you can't afford one, and to have a lawyer. You have a right to bail and to make the state prove the probation violation beyond a reasonable doubt. Do you understand those things? How do you want to proceed? Do you want a lawyer here? Do you want to have an extradition hearing? Or do you want to agree to go to Kentucky? Okay, so you want a lawyer? Who? Because you had a case here recently. Yeah, I was kind of surprised to see you still in jail. So you got a holder from Kentucky, that's why you didn't get out of jail. Who represented you? Do you remember the lawyer's name who represented you here? Okay. Fine. Who represented her? Her case was just concluded. Okay, you may be in the back. Mr. Steyer represents you, and he's here, so I'm going to go ahead and appoint him on this. Let him talk to you about it. And we'll have you come back out after you talk with him, and we'll decide what your bond should be, after you talk to your lawyer. Okay, you're welcome.
State of Ohio versus Scott Allen Wilson Jr., case number CRB 25673, A and B.
She's still in jail. I just got a hold of her from Kentucky. So are you Scott Allen Wilson Jr.?
I am.
Mr. Wilson, it's alleged in case number 673A that at Perry Township, October the 18th, 2025, you purposely tried to deprive Marathon of property without their consent. It's a theft charge, maximum penalty 6 months in jail, $1,000 fine. Same time and place is alleged that you committed resisting arrest, which is recklessly or by force interfering with the lawful arrest of yourself. It's a second-degree misdemeanor. Maximum penalty 90 days in jail, $750 fine. Do you understand these two charges?
I do.
How do you wish to plead to them?
I'm going to plead no contest.
If you enter a no contest plea, you're telling me that you don't want to fight these charges. You're agreeing that I can find you guilty without a trial and a lawyer if I believe what the state says it has as evidence is legally enough to convict you.
Yes, sir.
Is that what you want to do?
Yes, sir.
All right, Mr. Hill, do you have a statement you want to give me about the state's evidence?
I do, Your Honor. This is Deputy Nathan Cochran from the Lawrence County Sheriff's Office. On October 18th, 2025, around 2 o'clock in the morning, I arrived at 132 County Road 450 Marathon to purchase fuel and other items from inside the store while on duty. I entered the store and purchased my items. After purchasing the items, I was speaking to the store clerk, Kevin Davis. While speaking with Kevin, a male that was later identified as Scott Wilson Jr. entered the store. Shortly after entering the store, Scott walked toward the drink coolers, opened one of the coolers, and then proceeded to walk out of the store without any items in his hand and not stopping at the counter to purchase any items. I advised Kevin to check the security cameras to make sure Scott hadn't stolen any items. I exited the store while Kevin was checking the cameras in order to keep Scott in my sight. Kevin exited the store and advised me Scott had placed a drink in his hoodie pocket prior to exiting the store. I entered my patrol car and pulled up behind Scott at the intersection of County Road 450 and Township Road 616. I activated my emergency lights to attempt to get Scott to stop walking. I exited my patrol car and told Scott to stop walking away from me multiple times. Scott continued to walk away and asked why I wanted him to stop. I told Scott I wanted him to stop because he had stolen a drink from the gas station. Scott removed the drink from his hoodie pocket and threw it on the ground as he was continuing to walk away. I caught up to Scott and told him to place his hands behind his back, and he stated, "You can't arrest me, you're not a cop." I attempted to place Scott's hands behind his back to handcuff him. Scott proceeded to tense up and pull away from me. I removed my taser from its holster and deployed it. The first deployment had no effect on Scott, so I deployed my taser a second time. It also had no effect. After the second taser deployment, I notified dispatch that I had deployed my taser and it had failed. I requested another unit to respond to my location due to Scott not cooperating. Scott turned away from me and placed his hands behind his back. I placed Scott in handcuffs with no further incident. Patrolman Hutchinson with the South Point Police Department arrived on scene. As I was placing Scott in handcuffs, I walked Scott to my patrol car and began examining where the taser prongs were located on his body. One taser prong was removed from Scott's hoodie and another from his upper torso. The remaining taser prongs were in the ground near Scott's feet. I removed the prongs and placed Scott in the back of my patrol car. I returned to Marathon and began speaking with Kevin. I returned the drink to Kevin and gathered a written statement. In a written statement, Kevin advised that he was speaking with me after I had purchased my item. When he witnessed Scott walk into the store, Kevin stated Scott opened one of the cooler doors and then exited the store. Kevin advised he then reviewed the store cameras and observed Scott steal a prime drink. Kevin stated Scott placed the drink in his hoodie pocket. Kevin advised he then confirmed with me that Scott had stolen an item from the store. I then transported Scott to the Lawrence County Jail with no further incident. I routed both my taser cartridges into evidence. The total cost of the drink stolen was $2.46. Kevin filmed the camera footage on his cell phone and provided it to me through my work email. The video will be provided to investigation in the prosecutor's office.
Excuse me, may I say something?
You may.
Anything supposed to have body cameras on there? Body cameras on their uniform?
Would you want to enter a not guilty plea now, or?
Yes, sir.
Okay. I want to enter a not guilty plea for you. Do you want a lawyer?
I do.
Are you working?
I am not. I'm currently unemployed and homeless.
I'll appoint Mr. Stratton. Where are you from originally, Mr. Wilson?
I'm from Hillsborough County, Florida. I live in Birmingham. Yes, sir. I have no idea what I'm going to do. I didn't even know why I went on.
All right, I'll set bond at $500 cash assured. Might want to talk to him and see if we can deal with this later.
What do you want to recall?
State of Ohio versus Cindy Wood, case number CRB 25670.
Okay. Yeah, I'll talk. Yeah. Ma'am, are you Cindy Wood? Ms. Wood, you're charged with criminal trespass on October 19, 2025, that you, in Union Township, entered on the premises of another without the right to do so. That's a 4th-degree misdemeanor, maximum penalty is 30 days in jail, $250 fine. And you have a right to remain silent, you don't have to say anything, you have a right to have an attorney, to have bond, and to make the state prove this charge beyond a reasonable doubt. You understand those things? How do you plead? You want a lawyer? Do you have a job?
No.
You have no income?
No.
Okay, she has a co-defendant with Mr. Lewis, I believe. Who's representing? I know, but I'll let him get it on. Stratton, I think, was representing him, I believe. Mr. Morford, I'm going to appoint you to represent Ms. Wood. And you got a Chesapeake address, right? I'll give you a $2,500 signature bond. And when we need to set this on the same day as the 3rd. Seven. Can you do the 7th, Mr. Walker?
I believe so.
Okay. November 7th will be the next hearing, pre-trial, 10 o'clock. You're welcome.
State of Ohio recalls Willard Starkey, case number CRB 25671, CRA 25666.
It's on a recall. Mr. Woodward is the attorney.
Judge, I believe that he's waiting on telephone call. In the program.
This is an extradition and,
He's going to waive that.
now we do both treatment and extradition.
Well, I think the offer was he would just go to West Virginia and get time credit for time served.
That's what we.
We're going to take that on that offer, Judge.
Okay. So he's changing his plea on the possession of a drug abuse instrument?
Yes, you're guilty, Your Honor.
Is that correct, Mr. Starkey?
Yes, sir.
Do you have anything you want to tell me about it?
Yes, sir.
And you're agreeing to waive extradition and go to West Virginia and face the charges that are over there? That's also part of the deal. And it looks like those are more serious than the charges here. to direct Cabell County to pick him up by 8 a.m. next Monday, which is the 27th. If he's still in our jail on October 27th at 10 a.m., we'll have a hearing about it. Have him sign the waiver of extradition. All right, so he signed the extradition. Cabell County can be notified immediately he's going to be available, because I'm going to sentence him on this misdemeanor case and make him available to them as soon as they want to pick him up. So, possession of a drug use instrument. I'll impose a $50 fine and court costs. $15 days in jail. He can be released though whenever Cabell County wishes to pick him up, and the remaining time will run concurrent with jail in Cabell County. And I won't set it, well, I guess I should set a reading here. Level 5 probation for 2 years, April 27th through the hearing. April 27th.
April 27th.
He's released to Cabell County, and any remaining time runs concurrent with their warrant. Yep.
State of Ohio recalls Timothy Dow to court, case number CRB 25589.
Mr. Steyer's case.
Your Honor, I just spoke to Brandon Peters from Mended Reeds. He advised that Mr. Dow is signed up and participating in services. There's just not enough information yet to form a report. But I asked him if we came back in a couple weeks on the 3rd, if you think he could have a report by that date. He said he thinks he could. So I'm going to ask to continue this to the 3rd for that purpose. And we would waive time constraints to accommodate that.
November 3rd for a pretrial at 10 o'clock.
Write that down, man.
State of Ohio recalls Christopher Harper to court, case number CRB 25672.
This is a case the state was going to check to see if we can get a restitution amount.
Well, we got a hold of the right people, but they didn't know this had even happened until today. So unfortunately, we won't be able to get a restitution figure today. But our primary concern is going to be restitution, and I realize that Mr. Harper has a Louisiana address, so I don't know if he's going to continue to be in this area, whether he's...
No, sir, I was just here just for work.
Is your work finished, or are you still working on the project?
I'm still working on a project because of this stuff, though. I had to take a couple of nights off, so I don't know. They might want to lay me off because of this process, which would mean, you know, no, not employed, no more checks. So,
We don't want that.
yeah.
Well, I can set it, well, probably shouldn't set it this right. I could set it for next Monday, the 27th. You want to come back then, or would you like more time before you come back?
No, I would like more time. From my understanding, I talked to Miss Renata, and she talked to the woman, and she didn't know nothing about it until, like, I don't know, maybe 45 minutes ago.
Okay.
So, I mean, so I can understand why it's taking a minute to assess the damage. I just didn't know who actually went through with the charges. That was the whole thing.
Okay, you want a month then to come back?
No, I want to get it done as soon as possible. So next Monday will be fine.
Oh, so you do want to come back on next Monday, okay. October 27th then will be your next hearing.
If anything comes before then, can I pay it and not have to come back to court?
You can contact the prosecutor's office if they want to reach an agreement with you to that effect. I'm okay with it, but we won't have court, we'll have court Friday, but it's a terrible volume. I think today's bad, it's much worse Friday. Okay, October 27th is your next hearing at 10 o'clock. Your bond is continued.
State of Ohio versus Amy Van Zant, case number CRA 25458 and B, TRC 25830.
So my bond's still invested.
Mr. Smith's case, preliminary hearing.
Excuse me.
Judge, to speak to my client, there's an outstanding theft charge that we would go ahead and enter a plea on at this time. She has an appointment tomorrow with OVP.
10 a.m.
10 a.m. There was an F3 tamper. We're kind of holding out to see how she does in treatment. And it's over to Ashland OVP. But she would at this point speak with the prosecutor, enter a guilty plea on the theft, but hold sentence in abeyance till we hopefully successfully complete treatment.
Well, there's other charges other than that, isn't there?
She's pled to
There's an OVI also.
She pled to that previously.
Don't open up that.
She's got a tampering and possession pending.
I misspoke, just, she does not want to plead on the theft. The OVI she did enter a plea on, I think that's on the sentencing docket. And I misspoke on the theft. She does not want to enter a plea on that.
Set it for trial?
Yeah.
Did it arise out of the same incident?
No, I don't think it did.
The theft was on July 26th, and then the tampering and possession were 2 days later.
Are you keeping those here, or are you?
Well, let's make sure. I guess we always have that option to
July
just take it.
27th was the tampering.
Marathon.
July 26th was the theft. It's a day before.
Yeah. You know, we want her to go to treatment, and we're okay to continue everything one time and see how she's doing in treatment, then we can make a decision about the trial on
Appreciate
after a
that,
later
yeah.
date.
Hopefully-
She's in treatment now?
She's got an appointment 10 o'clock tomorrow at the Ashland OVP.
Ashland OVP, so I just did the assessment.
She's had the assessment, they've
Over the
accepted her.
phone.
She starts tomorrow at 10 as her first appointment.
Yeah, 10 with the doctor, with the counselor, and then the doctor.
So we were here on September the 5th, this might change my mind, and she had an appointment at Mended Reeds at that time, and things, I mean, we'd already had this case going since July, so I don't know what the cause of the delay is, but.
It's something with the medical card, I
Medical
don't know.
card, yeah, because where I'm at, care of Kentucky, Kentucky resident, so they wouldn't accept that. So then I had to find another place, which I found OVP, and then they recommended me the one in South Dakota, recommended me the one in Ashland. And that's where the appointment came.
Because you live in Ashland?
Yes.
That's where your medical card is?
Yes.
So we're at in Ashland?
Ashland, Kentucky.
Ashland OVP, she's got an Ohio WellCare, or Kentucky
Kentucky
WellCare. It sounds like she wasn't thumbing her nose at you, she was just trying to get it where she could.
So what we would expect then is that the next time we come back, she needs to be not only, you know, just started, but have some record of compliance. And that's going to influence our decision about whether we would take those felony cases to the grand jury or not.
I understand, Judge, and I told her to make sure she signs the release in OVP so that everybody can get a copy of her progress.
When you want to come back in a month?
A month would be fine, Judge. I could do the,
21st?
that'd be fine. December, November, yes.
November 21st.
Yeah, check with the clerk, I don't know the fax number, they can fax me the clerk, get what you leave.
And also,
Just need that, and you can give it to the treatment.
they need to make a decision. Is it a decision that there's not going to be any further consideration of whether she's going to plead guilty to the theft charge? I mean, are we definitely going to have a trial?
Well,
or-
she doesn't, she's adamant she's not guilty of the theft, so we'll
Okay.
have to figure out next time how we handle that. 21st and 10, February 21st. And we check with the clerk, I think we have the fax number.
State of Ohio versus William Kecklinger, case number CRA 24631. CRB 1152.
I watched the antenna today.
His defendant seen the report?
I believe he understands what's in the report. He's discussed it with me before. Again, it's his desire to move to outpatient treatment. I think his reasoning is sound. Obviously, the provider, probably even necessarily disagrees with the reason. They just feel that he's not ready. I think if we took a chance on him, he could prove him wrong and continue to do well.
Mr. Hill?
I knew that there was going to be that discussion about moving him to outpatient, and I understand why he wants to. I hope that he understands that the treatment team, as well as the court, has his best interest at heart, and sometimes there are things that maybe the people that are helping him have a better perspective. And we want him to succeed this time. He's been here a long time. It would be a shame for this not to be a permanent solution for him.
Yeah, I definitely want to, continue with outpatient no matter what.
Well, I'm not going to overlook what the people that work with him most are recommending.
I mean, he just told me 30, 60 more days and they would recommend it, so I'm good with that.
Well, let's come back in another 30 days and we should be close to going to outpatient.
So that would be
21st.
21st of available.
November 21st is the next one.
Thank you.
State of Ohio versus Kenny Ingalls, case number CRA 25-487-8D, CRC 24-2136-8D, CRA 24-662, CRB 24-663, CRB 24-546, CRB 19-847, CRA 18-517,
I think Mr. Ingalls just needs to go to the grand jury. Well, what's the state's position on that? He left treatment against medical advice.
I'm at Regal now.
I don't want to hear from you. You talk to your lawyer.
We would have to set the hearing for a preliminary hearing for a date in the near future unless he's willing to waive. But as far as the bond, wouldn't want him out unless he was in treatment somewhere.
He is in treatment, but he picks his own, he makes his own rules. Regardless of what the court tells him, he decides what he's going to do, how he's going to do it, and when he's going to do it.
I will say in his defense, Your Honor, he has done well with Regal, including getting some community service done and some payments. Working, I'm not sure if it's payments toward fines or just work toward fines. But he's made some payments toward fines and gotten some community service done while he's in there. So we are seeing positive progress, although obviously not necessarily in the way the court was looking for. So I think this could have been worse, is what I would say. And it is his intention, he told me that it's his intention to remain there and to continue treatment, if the court allows him to do so.
He's got multiple. Why in the world he would think he can take it upon himself to leave treatment when he's been told where he's supposed to go He's got felonies pending, he's got OBIs pending. He just needs to go back to jail. I'm gonna put his bond is back to 25,000 cash or surety. Preliminary hearing for next Monday. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
He will remain in custody. Do not take people into treatment when they come from another facility. When they leave against medical advice, go back and tell your boss, I said that. He needs to come into court and ask for permission to leave. You can't do it on your own.
State of Ohio versus Evan Holmes, case number CRC 25-2696 A and B.
You're Evan J. Holmes? Okay, this is case number 25-2696 A and B. It alleges that on October the 19th at 1:45 a.m., County Road 144, that you were operating a motor vehicle under the influence of alcohol or drugs, that you refused to take tests. That's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,075 fine, 3-year license suspension. I was told before court that this was not a first offense, but I don't see anything on the charging document saying it was not a first offense. Do you have any information on that?
Yes, and I'll have to make sure that I got everything straight, but he has priors in Ironton Municipal Court. This might be a third, even. But I can confirm that, Your Honor.
Okay.
Can we look it up? Ironton Municipal. Here, I'll do it.
Well, if it's a third degree, or a third offense, that makes it a maximum penalty of 1 year in jail. $2,750 fine. And a 10-year license suspension. Okay. Well, according to the clerk, he had an OBI here in 2022, so I don't know. Is there more than one in Iron Municipal?
I am going to find out here. He's got an OVI and a hit skip in March of '25. That's when it was filed. And he had previously pled guilty on that charge back in April. So there's the one there and one here.
So this is a third offense. Okay, so what I told you was correct about possible penalties. There is possible forfeiture of the vehicle also that was registered to you on third offense. There's also a charge of leaving the scene of accident accident, that's a first degree misdemeanor, maximum penalty is 6 months jail, $1,000 fine. And misconduct at emergency. That's also a first degree misdemeanor. Do you have the money to hire a lawyer?
No, Your Honor.
Are you working?
I'm in school, working at ACTC.
Okay. I'll appoint Mr. Steyer. Entering a not guilty plea for you. State's position on bond.
State would request a $2,500 cash surety bond. And if he's released in order to not drink.
What if he went to treatment?
Would be okay with that, sure.
Okay, I'm going to allow him to sign a $2,500 signature bond on the condition that he goes to Bethesda for inpatient treatment.
Somebody able to give an assessment?
Yeah.
Oh, I didn't see you walk out, sorry.
November 3rd.
That would be fine, Your Honor.
Okay, next hearing is going to be November 3rd for a pre-trial. You agree to go to treatment?
Yes, Your Honor.
Okay. All right. Go there, address issues, come back with a good report on November 3rd. Anything else? And you have to stay. You have to do what they tell you to do, when they tell you to do it, and how they tell you to do it.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Portia Nicole Anderson here at the court, case number CRA 25642, CRC 252585, CRA 25498.
Mr. Stratus?
Yes, Your Honor, this is actually set for a preliminary hearing, but, so we're waiting on some results from the OVI, which I don't think we have yet.
We do not have those.
Second thing is that I know this is charged as a felony receiving stolen property, but I don't believe that's a charge that the state intends to pursue.
As a felony.
As a felony.
It was a license plate.
Okay.
When she was in jail the other day, we thought it was a stolen vehicle, but it was a license plate. So I don't know what her explanation is going to be for having a stolen plate, but I don't think she's going to be completely innocent on that. But we're also concerned about the OVI, and we don't have your results back yet.
Yes, so Your Honor, we asked to be reset for another pretrial.
You have a preference on a date?
I don't know when the state thinks those results are going to come back,
Well,
maybe.
usually it's 9 or 10 weeks before.
Yeah, so maybe sometime in November. But we'll have some evidence also on the license plate issue. The only, so 3rd, 10th, and 24th.
It's not going to be the 9th week until the 2nd week of December.
We can go December, Your Honor.
Because I've got it out of state. Is she out of state or
No, I'm here.
local?
I'm
She's
local.
now. Okay. How about 8th or 12th of December?
December 12th, Your Honor. December 12th.
December 12th will be the next hearing on both matters.
All right.
Now, the 9th, let's see, the stop was on October 9th. All right, so we got till January, early January.
Yeah, that's actually the 9th week, is that week of December 8th.
Yep.
And we'll be lucky to have the results by then. A lot of times it takes 10 weeks.
All right, thank you, Your Honor.
You're welcome.
All right.
Thank you.
State of Ohio versus Rodney Spears, here at court, case number CRA 25-498.
Mr. Stratton's case.
Your Honor, Mr. Spears is doing wonderful at TCC. He does have an ankle monitor. I think that it might be time to let him off that ankle monitor. I know the court needs it anyway, so.
Yes. He hasn't been on very long.
Yeah, he's local, Your Honor. He's not, I'm confident he's not going to be going anywhere, so. I just know that there's people in jail waiting on the ankle monitor, so I thought I'd offer that up.
Mr. Irvin, do you dare render any opinion on that, or?
You know, technically, I'm not supposed to give my opinion in that regard, but I think the monitor, I think originally the monitor was placed just to keep him put since he was in a detox situation. We're not in that situation any longer.
Okay. I'm reading between the lines that you think it's okay to take it off. Now, I've taken it off people and that within a day or two, they're gone. As soon as I take off the monitor, it's happening.
Well, we do have a felony here, Your Honor, so.
I mean, I'm not saying that their charges are gone, but they split when the monitor goes away. So, at least tell me, Mr. Spears, that you're going to do this. That you're going to stay.
He will stay, yeah.
Okay. I'll order it removed. See Mr. Major. Set the next hearing. What's your dates again?
3/10 and 24 are bad dates. So
14th?
14th, yes.
November 14th will be the next hearing. Okay. We look forward to a good report then.
Absolutely. All right, thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Douglas Smith, case number CRA 25-380. Your Honor, he was on helicopter from the jail.
Okay. So this is for an arraignment. So he's busting down the doors to get into jail now, it seems like. Sir, you Douglas Smith? Can you hear me okay, Mr. Smith? I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. You are appearing in court today. You missed the bus. I mean, I guess you came in later, or they didn't know you were in the back or something. Anyway, we got a bus load here already in person. So
I was in town in court.
Oh, okay, so you were across the street.
Yes, sir.
So this is an arraignment for you on a new charge. Well, you haven't been arraigned on it. Actually, it's alleged to have happened in the summer sometime. You have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state of Ohio approve this charge beyond a reasonable doubt. You understand those things?
Yes, sir.
The charge against you is tampering with evidence. It's alleged on June the 5th of this year in Union Township, knowing there was a proceeding or investigation progress or about to be started, altered or concealed a thing with purpose to impair its availability as evidence in that investigation. So that's a felony of the 3rd degree, maximum penalty 5 years in jail, $8,000 fine. Oh, so they're charging you with removing an ankle monitor, so that's what happens when you remove an ankle monitor. They charge you with tampering with evidence. I guess one of the things they can charge you with. Oh, okay. So, do you understand this charge?
Yes, sir.
Do you have a lawyer in common, please?
No.
Have they appointed you a lawyer in common police court yet?
Oh, for my felony charges?
Yes, sir.
Yeah, I actually pled guilty to that today. I had, Roger Smith.
Okay, well, he's practicing in this court, so I'm going to appoint, since you know him, he's familiar with you, I'm going to appoint him to represent you on this charge too. See, did he leave?
I believe he left. It looks like he only had one case. You want me to stand up for him?
So you pled guilty today, did they sentence you today, or you got sentencing coming up sometime?
I have sentencing coming up on November 13th.
Okay, so we need to come back here. Well, he's in custody, so, and guess we need to just set it for next Monday. So I'm going to set your next hearing on this for October 27th. Preliminary hearing, appoint Mr. Smith. I'll let him know that I've appointed him to represent you. I guess bond is academic because he can't get out. But do you have a bond you want to put on it, or?
I'm just wondering whether this charge we have here wasn't included in what he just.
It might have been. Did you show
That's what I was understanding when I pled guilty today, that everything, it was included in the indictment, and I ultimately ended up pleading guilty to 11 years today.
All right, so it may not have been included, but it looks to me like he got a substantial prison sentence yesterday. So,
Yes, sir.
I'll tell you what we'll do. We'll go ahead and nollie this to the grand jury, and then we can take care of it internally in the prosecutor's office.
Okay. All right, so what they're going to do, in this court, they're just going to dismiss it. Then they'll decide if they want to take it to the grand jury or not. If they feel like you've already got enough, they may just drop it and not go forward with it. But Mr. Smith, I'm sure, would probably be appointed to represent you if they decide to take it back to the grand jury. So, but in this court, you're done. I'm not going to go forward with it. It'll be dismissed.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Erica Williams, case number CRA 25665. Back and holding, Your Honor.
This is Mr. Steyer's case. On our expedition to Boyd County.
Your Honor, Ms. Williams, I discussed the matter with Ms. Williams. She's prepared to waive extradition at this time and ask that they be given a brief time period in which we'll get her. I don't believe she can make a bond, so we're just going to ask that that time start immediately.
Okay. They asked for no bond. She can't post any. I would set some bond, so I'm going to give them till next Monday. And put her back on the docket for Monday at 10 o'clock in case she's still in the jail. That way we'll keep tabs on her, make sure she does go to Kentucky.
Thank you.
Thank you. She'll need to sign this waiver. And I know there's a few that they've got to pick up, so they need to bring a large vehicle, probably full of our people, over to make the exchange.
This charge was not included. This would have had to have happened before. So I nollied it. We can look at it. I mean, it doesn't need to go to grand jury. See, now it goes down here.
Where's the files at?
I don't know. I think it's a full charge. It's not, you know, like severance.
Okay, set for waiver to Kentucky.
Thank you.
Put it on the docket for the 27th at 10 o'clock.
State of Ohio recalls Scott Allen Wilson Jr., case number CRB 25673, A and B.
Mr. Stratton's case, I talked with Mr. Wilson, thought maybe we could resolve this today.
Probably recommendation, treatments. Robert, Mr. Wilson, I spoke with him, guilty of the charges. So he was, went through quite a few treatment providers until I learned that Harmony Ridge, which they will assess him and allow him to come.
Is that Barbershop? That where Harmony Ridge is?
I don't know. I'm sorry. I thought I was on the car. We went through, Bethesda's going to take him, Public's going to take him, RRS going to take him, so.
Does anyone know, is Harmony Ridge in Barbershop?
Yes, it is.
Okay. How are we gonna, somebody go transport him?
I have no idea. I mean, they probably would come get him.
Yeah, I know of them, but they don't work with us a lot, so I don't know if they transport or not.
I don't know if they do or not, but Richie Armstrong got his number, so. But yeah, so we'll go through the charges and ask them to give out.
Okay, do you agree with that, Mr. Wilson?
I do.
Anything you want to say?
I just apologize for whatever.
Okay, so on both charges, he's been in since Saturday? Yeah, Saturday. So I'll give him, I will waive the fine on the theft offense. Order him to pay the court costs. 2 days in jail, credit for 2 days served. Order him to seek treatment at Harmony Ridge as a part of his probation, 2 years of level 5 probation. Same sentence on the resisting, the B case. So he'll get out today.
He needs to speak with Harmony Ridge. They have not talked to him yet, but to speak with them. So I'll give him his card.
Okay.
When he gets to jail, it's the call.
No community service
No community service.
or DEA?
Yeah, April 27th.
State of Ohio recalls Justin Dale Higgins, case number CRA 25667.
All right, Mr. Morford, this is your case.
Hometown, I believe judge has agreed to accept him.
Okay. I'm going to require him to have an ankle monitor. So he can sign a $2,500 OR bond. GPS monitor is required. If you cut the ankle monitor off, it's an automatic trip to prison. Do not do that. What's that?
He's asking the bond amount.
So as long as you show up in court, you don't have to post 20, you don't have to pay $2,500. If you leave, well, worst part about leaving, the only way you can leave and get away is cut the ankle monitor off. Because they're gonna know right where you are if you have the ankle monitor on. So, if you cut the ankle monitor off, we just had a guy that they charged with tampering with evidence, a felony 3, 5 years in jail, $8,000 fine for last week, and it'll be out of my hands. You'll go to common pleas, and they're gonna send, yes, Mr. Moore, everybody that does it gets 3 years in prison for cutting an ankle monitor off. We need to set a hearing date, 2 weeks, November 3rd. He had been set for the 10th, so let's move it up to November 3rd. I don't know why the old meeting was set.
We never even went through here yet. We haven't even started the process, that's why. Who's the treatment provider? Yeah,
Hometown.
that's the one right here. They just put it- That's the one.
So we know what this is the grand jury.
Yes.
And you can think about, well, we gotta get the monitor, so we need to coordinate with the adult probation. and Get the monitor placed.
That's the second one.
State of Ohio versus Brianne Hensley, here at court, case number CRB 23-350.
Your Honor, this was set for trial today. There's going to be a joint recommendation that we continue this trial. I'd like to set it sometime maybe in latter part of November, first part of December. Ms. Hensley just started a new job and she on a 30-day probationary period, and she doesn't want to lose that job.
Well, we can even go first of December.
The 1st and the 8th in December are bad for me.
December 5th.
Yep, that'll work.
And that's, is that gonna say it's a trial or a pre-trial?
That's a trial date, Your Honor.
Trial, December 5th, and
State of Ohio versus Andrea Jones, case number CRB 25-439.
It's December 5th.
What's the date?
December 5th.
are you still, or you, okay?
Yes, sir.
You coming, your report? Yes.
That's what I thought they said.
It's a good report, good screens. Does it matter if it's Mondays or Fridays?
No.
December the 8th. 10 o'clock.
Ten o'clock?
10 o'clock.
Thank you.
State of Ohio versus Tara Stover, case number CRB 25590. Tara Stover.
May I approach you?
Yes. So she did stay and do the screening for them.
She did do the screen. I spoke with her afterwards concerning the positive alcohol screen, and she tried the cough medicine excuse, and then when I confronted her with the ingredient not being in there, she admitted to accidentally drinking lemonade, and I told her our recommendation was going to be residential. She left. This conversation was witnessed in front of Josh and John. She's made some accusations now that, you know, I was mean to her.
All right, she'll get a warrant for failure to appear today.
Thank you, Your Honor.
Thank you.
State of Ohio versus Tiffany Strange, case number CRB 21773 A and B.
On this docket. Just to make sure you get stuff done. So I've got a letter dated October 13th from Marshall Health.
From ProAct? Yes,
So you're still on there.
yes. November makes a year I've been there.
Yeah. Okay,
And then I finished my community service. I have this paper.
okay, let's get Mr. Cooper in. Where did you do your community service?
I came here and signed in, and they sent me to animal shelter every day. I've still actually been volunteering there afterwards.
Your Honor, I updated her review this morning. There should be an updated thing in there. I believe all she has is $50.
Okay, I'm showing, I don't know, check it. I'm not showing anything there. It says 0. Let's see.
I thought I paid everything.
She very well could be finished. I may be wrong.
$50.
I do owe 50.
Yes. On the 2173 A.
Can I come in and pay it Wednesday?
You can?
And I can pay the whole 50 Wednesday.
Your Honor, she can check with me before she pays that. If she's got some other community service, it covers it all.
Okay. He did extra community
Yeah, I
service.
did do an extra day.
Then that should take care of it.
I'll just have to verify that, make sure I haven't already gave her credit for something.
So I don't need to pay the 50 then?
Come in and check with us.
Okay.
Okay, you were out of pocket for a while, so I want you to continue. I think it's good for you to go to ProAct.
Yes, I am. I'm going to. I really like the counselors there.
So I'm going to schedule you right before Christmas, and then maybe that'll be the last one.
Okay.
December 22nd. Bring me a report from ProAct,
All right.
and that'll be at 10 o'clock. December 22nd.
State of Ohio versus Michael S. Clay, case number CRB 2010-23, CRB 18-796, CRB 18-251.
It's a good letter.
It's a good report.
Thank you.
Are you still being supervised by common police?
Are you on probation anywhere else?
Yeah, okay. Okay, I think we should continue because there was a little hiccup back in August. So let's keep going. Maybe we can go a couple months before we come back. December? What's your schedule in December?
15th, I'm available.
Okay, that's fine. December 15th. 10 o'clock.
Thank you.
Thank you. Good job, man.
State of Ohio recalls Richard Riggle, case number CRB 25668,
Mr. Steyer's case, we haven't set bond yet.
If he's able to bond out, Your Honor, he has an appointment at 8 a.m. tomorrow for a full assessment at hometown.
Okay, what's the state's position on for Mr. Reed?
Well, we're all in favor of him going to treatment, and this incident was a little bit scary, I think, for Mr. Regal. There were a lot of things about it that caused concern. I'm glad he's willing to go to treatment. As far as him being released on an OR bond, I don't know whether it's a good idea for him to be released without some supervision now or not.
I mean, we have him set for tomorrow morning to go to the assessment. I think that's, we can send him back in relatively quickly.
Do you have a way to get there, or?
You have a way to get there? Yes. Yeah.
Okay.
Okay, I'll give him a $2,500 signature bond. Assessment at hometown tomorrow.
I have a hearing in Collin Police Court on Friday of this week, but I'm available again the 27th and 31st when we come back fairly quickly.
How about
Or the 3rd.
the 31st?
I'm sorry?
It's actually the 31st. It's
Yeah,
Friday.
I'm available that day.
Okay, October 31st will be the next. For pre-term.
Thank you, Your Honor.
State of Ohio versus Reuben A. Mitchell. Here is the court, case number TRC 133933 A and B, CRE 131159.
Okay, this is on the review docket for today. You have a payment to make, Mr. Municipal?
Yes, Your Honor.
How much are you paying?
$70. $70.
70?
Yes, sir.
You'll see the clerk. And I'll set your next hearing. November 24th.
Thank you, Your Honor.
City clerk.
State of Ohio versus John Franklin, case number TRD 183567.
Okay, this is arraignment on the warrant. You're John Franklin?
Yes, sir.
It's alleged that you failed to come to a hearing, this is a while ago, March the 8th of 2019. And a warrant's been outstanding since then. So you came in on the warrant?
No, sir, I came in to pay the fines. I made a mistake that I don't have an excuse for. I misunderstood, or I didn't realize that I needed to come back, and that's why it's been hanging there so long. I came in to pay what I thought I needed to pay.
And they told you you had to come in court?
Yes, sir.
Okay, so do you admit or deny that you missed your hearing? You had a hearing set for sentencing, it looks like, on March the 8th, 2019, and didn't appear.
I admit, I don't have an excuse. I guess I misunderstood.
It was if you want to see it, your next hearings are, and it says March the 8th, 2019, 9 a.m. See, it's on the judgment entry.
Probation officer. I do see it, yes, I do see it. I apologize, I don't have an excuse. I don't know how I made a mistake.
Okay, can you pay, you owe $235, can you pay that?
Yes, sir.
The whole thing?
Yes, sir.
All right, if you pay the whole thing, the case will be completed. I'm going to go to the clerk's office now and pay it. The case will be completed then.
Yes, sir, thank you very much.
Clerk's office to the right as you leave court.
Thank you.
You're welcome. Court's adjourned.
I just, we're going to have a preliminary hearing, so we need to figure out who the witnesses are.